Yes, Mr. Nabhan. Somebody told me that you are not well.
My lord, yes, my lord. Last week,
It's okay now.
now, my lord, still I am under medication, my lord.
Okay.
Medication.
Okay. Yes.
May I please, Lordship? Lordship, I beg to mention item number 6, Lordship.
Item number 6.
6, Lordship. Kindly, it may be taken up tomorrow, Lordship. Planet AG will be appearing in this case. He's coming tomorrow.
What is this interlocutory application form?
Extensions to the Lordship time period to comply the judgment, Lordship. In earlier judgment, Lordship, there was a time frame was given, Lordship. So within that time frame, Lordship, government is not positioned to, Lordship, comply the order. So we are seeking further time.
Extension of time.
Okay.
Okay.
Okay. Item 6. List on 2nd April. Yes.
Paula.
I beg to mention item number 3. Item number 3 and 4, Your Lordship. In both the items, we are for the respondents. My lord, the leading counsel for
because this is for admission.
Yes, Your Lordship. The leading, my lord, Mr. Pangin, the counsel for the respondents is out of station for.
Just renew the prayer when the matter reaches.
Okay.
Renew the prayer when the matter reaches.
May I please, Lordship? Lordship, I beg to mention item number 5. Lordship, here the paper book is ready and we have received the paper book on Friday. So kindly this matter may be listed after 2 weeks for hearing.
Then we'll have to pass the order and then fix it for hearing.
Yes.
Renew the prayer when the matter reaches.
Obliged.
Yeah, Your Lordship, we were directed to file our counter affidavit by 27th of March, Your Lordship, and we have received the parawise comment, Your Lordship. So I am praying, Your Lordship, to give us at least a week's time to file our affidavit.
Lordship, kindly this matter may be possible for timing because our leading counsel is stuck in the middle of the road due to a vehicle problem.
But they are asking for time, no?
Timing, Passover.
So for the time being.
Okay, getting down.
Yes.
Item number 2.
May I please, Your Lordship?
Yes, respondent. Yes, filed an affidavit, no.
My lord,
Filed an affidavit.
my lord, we have filed, just served this record to him, and might be, my lord, it has not been made up to Your Lordship's stage, my lord. My voice has filed it early morning, my lord.
Okay. You filed it today. You
Yes.
filed it today.
Yes, today I have received.
Can I have a copy?
But
for your affidavit?
respondent number 3, my lord.
Yes, yes.
My lord, regarding this solid waste management rules and all, we have published, my lord, already published.
You have published?
My lord.
When?
My lord, they are, my lord, given there, my lord.
Page 55.
You read the boss. You can rely on this one. मेरा ज्ञान आप रिले कर सकते हैं और तो कुछ नहीं जो आपको बोला ना हमको पे मेरा तो कहना कॉपी देना चाहिए था थोड़ा टाइम ले लेगा टाइम लेते हम आपको कॉपी दे देंगे अब अंदर नोटिफाई किया है कुछ ना
It's been implemented.
My lord.
Yes.
My lord, may I just read last order on 26/3/2025.
as per that, your lordship was pleased to all the order. One was for the publication in the uh, office, in the gazetteers, office gazette. And another was that, may I read that? The last
yes.
option, Mr. Sajal.
We have read it. You just tell us what is to be done.
Yes. Especially in this affidavit, it is silent about how they are going to uh, uh, install the dustbins in different places. And they have not mentioned even time frame also. Because in different colonies, there has to be a dustbin, has to be installed so that dustbins.
You are sure in this city people use dustbins?
I think many colonies, yes, because
I have a video of my own home, where in the dead of the night, nearly at about 12 o'clock, very respectable lady. She is seen coming down, going outside and throwing the garbage on the road. We have a video of it and the lady denies. Very respectable lady. But these are small things. Once
Yes.
they are notified.
Yes, yes.
Once they are notified, then we'll see how it is implemented.
Yes, yes, that's
But yes, garbage collection, I think this is started.
My lord.
Because this I have noticed in the early morning when I went out for a walk earlier. They have this van coming in for garbage collection. They put up a music.
music.
About Swachh Bharat. And we hear that music and we see them collecting it. This I have seen being implemented.
My lord, as your lordship has rightly pointed
But
out,
Mr. Jamo,
my lord,
this time I did not take the road in the near that garbage collection center in Itanagar.
my lord, yes,
Have you cleared the road?
my lord, yes, my lord. I will ensure, my lord. It was cleared, my lord. As of now, I have not visited, but I will ensure, my lord. If there is any remnant there, my lord.
Okay.
My lord.
Because that is a bad site. When
My
you,
lord,
when you
very
enter into the
bad side.
Itanagar,
Yes.
on the right side of the road, the for a few kilometers the trash is seen lying.
Yes. Even in colonies also it is, yeah, your lordship.
Can anybody in the room tell us, any learned counsel, have they seen this garbage dump in the Itanagar before, after Itanagar from here? Is it clean? Well, nobody can say. No.
In the last order 12/9/24, you were also supposed to give a timeline by what time the garbage collection, dustbins, etc. would be placed. Yeah, have you given the timeline?
Your lordship, actually, as my lordship has just pointed out, in Arunachal Pradesh, garbage installation of garbaging is not practical, my lord. We have installed it twice or thrice, my lord, but people here leave it or stole it, my lord, steal it, my lord. So what we have started here is we have started collecting garbage twice daily, my lord, home to home, ringing bells on our truck, my lord. In morning, we have given our time there, my lord. In morning we go, and in afternoon also we go, my lord. 2 times, my lord. That we have given in our affidavit, my lord.
Okay, let that affidavit come. We'll take it up next week.
Yes.
Okay, my lord.
Yes. Let us state all that. Yes.
Okay. All sides are represented. Next paragraph, Mr. T. Jammu, learned counsel number 3, submits that he has filed an affidavit which is not brought on record. So it is submitted that the Arunachal Pradesh solid waste within bracket management and handling bracket closed bylaws, 2023 was published in the Gazette, Arunachal Gazette on 6 December 2023. So it is submitted that the collection of garbage. So dustbin has failed. And in the affidavit filed by respondent number 3, it has been stated that the door-to-door collection of garbage is implemented twice a day. Next paragraph. That this affidavit be tagged with the record. Next paragraph, this time, next Monday. Next Monday would be 7th.
Yes.
Okay. So Mo, you'll have to tell us, is it being implemented or not?
All right.
Just before that, affidavit in opposition, if every reply, if any filed at least 2 days prior to the next date of listing.
Apply.
In practice.
Number 3.
Yes, in item number 3, there is a prayer for adjournment.
Yes, Your Lordship.
In fact, I am in 4. 3 is also similar. We were told that Dicky for some personal reason will be away from Shillong here to Guwahati. So that way I was also.
Okay. When do you want?
After Bihu break, Your Lordship. After Bihu break, Your Lordship.
After Bihu break.
Bihu vacation. Huh?
Mr. Arsekia, item number 3, Mr. Arsekia, counsel for the appellant. GSM is there, Mr. Ridham, Mr. Y. Ridham, the government advocate, and Mr. Parmet,
28%.
Next one. On the prayer made by Ms.
31st.
I forgot your name.
D. Tamuk, Your Lordship.
The respondent, private respondent, the matter stands adjourned today. List on. Give me data.
Let it be 31st. It's a Thursday hearing day.
31st.
30.
But it's not even been admitted. Hearing is a distant date.
My Lordship may admit, we don't know difficult.
Huh?
But then difficult, once it is admitted, it will go for hearing, the matter will never come up for.
No, but keeping it in admission.
My Lord.
Always.
Then before vacation, 7th, can it be done? Then let's say be 21st. Immediately. Okay. 23rd?
We'll keep it on 31st, but we'll keep it on admission, not
yes.
Not on 30. We will make it 30.
All right.
Okay. 30. Because 31st we don't have.
There's no 31st.
We would have accommodated you.
What we do is we prepare a separate calendar for
that's
the
okay.
dates. I'm sorry.
That is the reason for
Your
not
Lordship
being
is
able to
absolutely
accommodate
correct.
you. 3042. And in the next item will be Mr. D. Muzumdar, Senior Counsel, assisted by Mr. P. Bora.
Only one issue is involved in the entire case.
We have seen that. Retrospective. From the date of.
The only ground on which it was refused is that there was no vacancy. Otherwise, all other criteria required in terms of direct recruit case. Lordship will hear.
Let us see, we'll hear.
Lordship will hear.
Item number 5. Lordship, here we have received the paper book on Friday, so kindly it may be fixed for hearing.
Okay.
Yeah, they are saying they received it only
Okay. Your name?
T. Gyatso.
T.
Gyatso.
Mr. T. Gyatso on counsel for the appellant. Submits that he has received a copy of paperwork. Next, brother. Mr.
J. Zini for respondent number 2, Lordship, informant. presenting as legal counsel.
Who's the APP here?
Lordship, I don't find him in the court.
Huh?
He's not here in the court.
Who is the
APP last time?
Oh, okay. Mr. Tado was there.
Tado, yes, Mr. Tado was.
Okay, Mr. JG, corresponding to his visit. Next. It is submitted at the bar that the copy of paper has been made ready and served to all the parties. Next, accordingly, the case is ready for hearing. Next. This is the matter for hearing in the month of May 2025.
May.
Come whenever the registry fixes.
Okay.
Okay.
Your Lordship.
Yes.
Your Lordship, I'm seeking for an adjournment since the council, SB Dara, is out of station. Who's the PP? PP.
Okay. On the ground that the learned legal aid counsel for the appellant is out of station, where for adjournment has been made by Miss
N Hondik.
N
Hondik.
Learned, how do I spell it?
HONDIQUA.
Place for adjournment. Next for there's no representation from the state and the legal aid counsel for respondent number 2. Next one. As the paperwork is ready, this is the matter for hearing in the month.
Your Lordship,
Sorry, May 2025.
I4 respondent number 2. LSC.
What's your name?
Christina Iring. C. Iring.
T.
C. Iring.
C. Iring. Okay. Also, the respondent is present.
Lordship.
Fixing it for hearing.
For Thursday.
May 2025.
25. Deeply obliged, Lordship.
Lordship, tomorrow maybe.
Your Lordship, I'm seeking for only a week's time, Your Lordship, to file our affidavit, Your Lordship.
Week's time.
Yes, Your Lordship, because we have to file instruction in the form of affidavit, Your Lordship.
No, but this is something we shall have to comply with it. The request, the prayer made in the this PIL.
Yes, Your Lordship.
You will have to work out a mechanism to comply with these orders because public at large can't be disturbed. And the prayer here is that the action should be taken against the Deputy Commissioner Lower Sian, the DGP, and the officer in charge of the Likabali police station on their failure to adopt preventive measures.
My Lord, as per the last order, then we made a communication to the Deputy Commissioner and the SP, my lord. My lord, as per judicial order, based on the instruction given by the Deputy Commissioner SP, my lord, we need to file an affidavit, my lord. Now, my lord, so far that incident happened or not happened, my lord, that will clear by through this affidavit, my lord. Nothing major incident took place on that day, my lord.
No, but still it's disturbs the entire fabric. And now these things are also covered by UAPA.
My lord, yes.
It becomes a terrorist act.
Terrorist act. We have Arunachal Pradesh Preventive Act. We have that.
This is also covered. Okay.
Since there is a judicial order, we have to file the affidavit. Otherwise, my lord, last time also we raised the maintainability, my lord. We lost my grant of weeks, my lord, for next week.
What says the representative on the prayer made by Mr. R.S. Nabam additional representative, along with, assisted by Mr. Y.D. Ram, government advocate, the matter stands on today. So as to enable the state to file an affidavit in terms of one of the dated 5/3/2025. We are taking it up on Wednesday next. We file it by Monday. List on 9/4/2025. The affidavit in opposition shall be filed by 7/4/2025.
May I, Your Lordship? I beg to mention item number 13, Your Lordship. 13, Your Lordship. Your Lordship, there are some errors in the petition, Your Lordship. So liberty may be granted to withdraw the same, Your Lordship.
Okay. 13.
Item 13, Your Lordship.
Upon instruction, Mr. Your name? Your name?
P. Tatu, Your Lordship. P. Tatu.
But your name is not there in the Vagalatama.
Your Lordship, the councils are out of station. So
you're making a prayer on whose behalf?
B. Takar, Your Lordship.
On whose behalf?
B. Takar, B. Takar.
Oh, B. Takar. Item number 13.
13, yes. Tam Yadakan, Tam Yadakan.
Okay. Upon instructions, Mr.
Yes, Your Lordship, liberty may be granted.
Mr.
P. Tatu.
P. Tatu. Learned Counsel appearing on behalf of Mr. B. Takar, T-A-K-A-R, Learned Counsel for the petitioner, submits that there are certain mistakes in the petition and therefore he has instructions to withdraw the same and to file again. Mr. Y.D. Ram, the government advocate. Who others are there? None.
Yes, we are there.
Is present.
Press,
okay,
press,
because I will record the presence of parties. Mr. Y.D. Ram, the government advocate is present. Other respondents are not represented. Next, the prayer is allowed. The matter stands dismissed on withdrawal with liberty is paid for. Okay.
Your Lordship, item number 4, Your Lordship.
Yes.
We have not received the pair-wise comment, Your Lordship. So, may it be fixed after 2 weeks, Your Lordship.
So let us, this is a motion matters. You renew the prayer when the matter reaches.
Sure. And Your Lordship, if I may, item number 28, Your Lordship.
Yes.
We have not yet received the pair-wise comment, Your Lordship.
28.
I pray, Your Lordship, 2 weeks time may be granted, Your Lordship, to file our C.
Yep.
I have taken the consent, Your Lordship.
Give me a fixed name.
Okay.
Listed on 22nd.
We'll make it 23rd. But this is still in orders. Both sides are represented. On the prayer made by Mr. Y.D. Ram and the government advocate. Matter stands adjourned to enabling to file affidavit in the matter.
Yes, Your Lordship.
Next, the concerned respondent authorities shall ensure that the pair-wise comments is received by the government advocate so that the affidavit can be filed at least 2 days prior to the next date of listing. Next, list on 23/4/2025.
of last Lordship.
May, my lord.
Yes.
I would like to mention item number 26, my lord.
26.
Yes, my lord.
Yes.
My lord, in this case, I was directed to take justice service upon the private respondent. We have taken justice service upon the private respondent, but the documents which is in position of petitioner number 3, my lord, and he has some medical problem, so we could not file our affidavit. I need 2 weeks time.
Okay.
I have taken consent.
What says representative? No, just say Mr. B.P. Chalan, counsel for the petitioner, submits that. No, prays for some more time to file affidavit of the service by Dusty Mode.
Yes.
So Ram and the government advocate is present. Next list after 2 weeks.
2 weeks, man.
Okay.
Much obliged.
May I mention item number 17 on behalf of K. Tari?
Item
17, 17.
17.
Since his daughter is hospitalized due to a tonsil surgery, he couldn't present today. So matter may be fixed after 2 weeks.
Okay. Your prayer is on behalf of?
K. Tari. Respondent.
Okay. Respondent counsel.
Yes.
Okay. Both sides are represented. On the ground that Mr. K. Tari, learned counsel for the private respondent, is unwell. The prayer for adjournment is made by Mr.
H. Gyati.
H.K.
Hapun Gyati. H. Gyati.
Gyati. H. Gyati. Done, counsel. So prayer is allowed. Matters is adjourned today. List after
2 weeks.
2 weeks. Miss Anju, any interim order is there? No.
No.
Okay.
No.
Yes.
Lordship, I beg to mention item number 1. Lordship, this matter was supposed to be listed on the other stage. Here, this is a transfer posting matter, Your Lordship. On the last...
Let us see, because I have not seen that. Just read the prayer when the matter is called.
Yeah, Your Honor. Your Honor, I beg to mention item number 30.
30.
30, yes. I will inform the other side also.
You've taken consent of the other side?
Yes.
You have taken consent for the
Yes,
petitioner?
yes, I will take the consent.
Okay.
Your Honor, the matter may be released after 2 weeks.
Consent of the from the learned counsel for the petitioner, the prayer for adjournment is made by Mr.
B. Ping Chang.
B.
Ping Chang.
Is right. So learned counsel for you are on behalf of?
I'm on behalf of X. Gyati.
On behalf of Ms. S. Gyati.
X. Gyati, yes.
You're for the petitioner?
Yes, yes, petitioner.
Okay. X. Gyati. Gyati. So prayer is allowed. Notice is adjourned today. List after 2 weeks. Okay. No, notice of motion is not been issued. You can't fix it for orders. But why you filed this petition?
Lordship, there is...
No adverse orders is passed.
Lordship, this is regarding the...
It appears to be a wrong advice to your petitioner to file this petition. He is still the treasury officer. He is given an additional charge of sub-treasury office. What is wrong in that?
Lordship, the petitioner, he is a Gazette A officer.
Is there any order passed to reduce your salary?
Lordship, here
Please tell me
Yes.
if I am, you see, you are aware of my status,
Yes, yes.
correct? Now, if I am made a guardian judge of this district judge here, district judge premises, would it mean that my status has been downgraded?
Lordship, originally the writ petitioner, he is a
Look at the
group A gazetted of Lordship.
look at
But
the
however, the impugned order,
please look at the order. Where is the reduction of your status? You are a treasury officer. You have been transferred as a treasury officer. You are just given an additional charge of a sub-treasury office. In addition, it's an additional charge. If you think that you are affected by, you should not be in service. You leave your service, resign from your service. You are too big for your boots.
Your Lordship, with due respect, Your Lordship,
Please look at the transfer order.
kindly, Your Lordship, let my senior counsel, let him come and, since I'm not aware about the brief,
If
Lordship.
that is the petitioner, then he should very well resign. He's unfit to be in government service. He's too touchy.
Lordship, connecting counsel, let
Ask him
him,
to be here.
yes, sir.
So he's too
Let him,
touchy. Am I right? Have I rightly understood?
Correctly.
Okay.
Lordship, kindly, I request this honorable court, kindly fix that may be given, so that connecting counsel, let him come by himself and present his argument before this honorable court.
Just on 2/4/2020 tomorrow.
No, for 10th April.
10th will be too far. 9th. 10th is a hearing day. List on 9. Oh, sorry. And 9/4/2020. That is straightforward counsel for the petitioner.
Sure.
Mr. S. Tapin, then the government advocates, senior government advocates present. Okay.
My lordship, the matter may be possible for timing because my senior is coming on the way.
Okay, timing.
Your Lordship,
Yes.
Admitted bill amount, release of bills.
We issue notice instead of keeping it in the motion column. It's a non-payment of bill.
Yes, sure.
Okay, we'll give you, but we issue notice. But Mr. K. SNL and counsel for the petitioner. Next, by alleging non-payment of contractual dues. The present writ petition has been filed under Article 226 of the Constitution of India. Issue notice returnable on, when do you want?
after 2 weeks, Your Lordship.
Returnable on 25/4/2025. Next, Mr. Y. Ram, the government advocate accepts notice on behalf of all the respondents, which accordingly requisite extra copies of the writ petition be served on him within 2 days. Next, the pendency of the writ petition shall not be a bar for the concerned respondent authorities to examine the claim of the petitioner and to release payment if found due. Next, based on censor.
Obligations. Your Lordship, this matter is arising out of the impugned court agenda dated 20 March 2000.
Which page?
Page 72, Your Lordship.
72.
Annexure 5, Your Lordship. Your Lordship, the Director of Planning has issued this corrigendum whereby the nomenclature of already approved and accorded project work.
How you are aggrieved by that?
Yes, Your Lordship.
How you are aggrieved by that?
Your Lordship, on 5th March, Your Lordship, this project was approved and accorded by the government of Arunachal Pradesh.
How are
And
you aggrieved? By the change of name, how are you aggrieved?
thereby, the Executive Engineering of Sagali, Your Lordship, has issued the work orders in favor of me, Your Lordship. And thereby, after issuance of such work orders, I have carried out the work, and up to 90% of the work is completed till today, Your Lordship. And the same progress report, it has been uploaded in the monitoring apps also.
Please tell me how you are affected. Just say, for example, there's a stream here which is called Papu Nala, correct? Yes. One fine morning, the government finds that a stream as Nala is not proper. They were named X River.
Yes.
You are doing some contract over that river. Is it affected?
No, Your Lordship, but
how you are aggrieved if it's not, if your work is not affected? Have they withdrawn the work from you?
Your Lordship, kindly face 44, Your Lordship.
I'm asking you a question. If I have to read, then I don't need your assistance. Please tell me, has any order adverse to your interest has been passed?
Yes, Your Lordship.
Where is that?
Your Lordship, page 44.
Yes. This is the order adverse to your interest.
Yes, Your Lordship, clause 2E, Your Lordship.
Yes.
It says specifically mentioned that funds should be utilized for the purpose for which it is allocated and cannot be diverted for any other purpose, Your Lordship. And in Annex A of the order.
Now let me give a horrible example. I'm good in giving horrible examples. I'm giving you one. You see, you go to a tailor, give him the measurement of your pant, and then the tailor says you come and pick it up on 10th. Now, before 10th, you go and swear an affidavit that my name should not be A, it should be read as B. Now, will your tailor say that I won't give it to you?
Yes,
Then, where is the order saying that this work is withdrawn because of the change of name? Tell me.
Your Lordship.
Or should I record that you are submitting that the work is because of the change of name? The work has been withdrawn from you.
Your Lordship, I have carried out as per the work orders only, Your Lordship. And I have put all my financial...
On an earlier time, when I was young, you may not have found it. Have you seen a record player? If there's a scratch in the record player, it stops there only. Don't be like that.
Your Lordship.
I'm asking you a question. Has any order adverse to your interest has been passed? It's a simple way as I can put it. After the change of name, has any order been passed which is adverse to your interest? Has your payment been stopped? Has your work been withdrawn? Have you been directed not to proceed any further in the work? Has anything of these three happened?
No, Your
You dismiss your repetition.
I believe, Your Lordship, please, this matter may be listed on tomorrow, Your Lordship.
Not tomorrow. We are dismissing it right now. If there's no order adverse to your interest, you can't keep it pending.
Your Lordship, this work has been diverted. That's why I have...
Show me a document. I'm asking you for the third time. Show me a document that this work has been withdrawn from you and diverted.
Your Lordship, page 72, itself, corrigendum, itself is a diversion, Your Lordship. The work this work has been awarded to me, Your Lordship. And thereby, after execution of such work.
Is there a contract with you that during the pendency of the work, the name of the work will not be altered? How you are agreed by that? Today, this road is made by PWD. Tomorrow, this will be made by BRO. After 3 days, this road will be taken over by the rural roads and they are being developed. How are you affected if your contract is not terminated?
Your Lordship, then my senior counsel may be.
No. He should have been here. You can't spend time and then say senior counsel.
Tomorrow, Your Lordship.
No. We are dismissing it right now. Heard, Mr.
Then Your Lordship, liberty may be given, Your Lordship.
Heard, Mr.
And Roma, Your Lordship.
We can't give you liberty. If only when there is an adverse interest, then you have the liberty. Otherwise, not.
Liberty, Your Lordship. I will show the order act.
Please. You see, if there is a change in circumstances, you have to file it. You don't need a liberty. It's a different order that you will be challenging.
In the impugned Korenjanta, there is no any reasons has been given, Your Lordship.
It is the prerogative of the government to change names. Today, this town is called Naharlagun, UPR. Tomorrow, this may change to a different name. How you are affected by that? Would it mean all the contracts are terminated? Allahabad became Prayagraj. Do you think that everything in the every government work which was going on has been terminated?
No, Your Lordship.
Name of the cities are changed. Guwahati becomes Guwahati. Calcutta becomes Kolkata.
Your Lordship.
Has any contract work terminated just because of that? Yes, what do you have to say?
If my lord allow, my lord, I like to assist my lord. Oh, my lord will kindly turn to page 72, my lord.
Page?
72, my lord. This is the
I'm there at 72.
In terms of this, my lord, now this maintenance work at LT line, Nijuli and Lakey, my lord, this falls under other subdivision, my lord. Accordingly, on our part also department, my lord, we have the Sagali division, my lord, has written for correction, my lord, for cancellation of this corrigendum, my lord. This corrigendum, my lord. Earlier work was in Sagali subdivision, my lord. Now this new work.
You also have the same question. Is any order being passed which is adverse to the interest of the petitioner? Will his work be terminated?
No, my lord.
No. That's all. We write your record of statement. Then
situation here is, my lord, earlier work here was in Sagali subdivision, my lord. Now this work has been since falls under this Naharlagun subdivision, my lord.
That is your interdepartmental headache. The only question I'm asking is, because of the change of nomenclature, change of the department, is any order adverse to the interest of the petitioner is being passed?
On our part, not.
Then, end of the matter. Heard, Mr.
And Roma, Your Lordship.
And
Roma.
And Roma, learned counsel for the petitioner. Also heard. L. Permit, learned standing counsel for the Power Department, representing respondent number 2, 3,
6, 7, and 8,
6, 7, and 8. And who will appear for this? You will be appearing. Ms. G.A.T. learned.
1.
Your designated senior committee advocate, additional senior committee advocate appearing for respondent number 1,
and
4, 5.
Yes.
1, 4, and 5. Next one. The petitioner was awarded the work of inverted commas, construction of extension of 11 kV line from where do I find that name?
Page 49, Your Lordship.
49.
Work orders.
Page 49. red pencil mark. So and so. For which work order was work order dated 6/3/20. The order number is also there in the same page. Red pencil mark. Work order number so and so dated 6/3/2025 was issued by the executive engineer within bracket E, bracket closed, Sagali Electrical Division. Full stop. By corrigendum under file number page 72. Dated 20th March 2025, give a semicolon, computer number 236910, issued by the Secretary within bracket Planning and Investment, comma, in partial modification to the said department's earlier order dated 12/3/2025, comma, the state government has approved the change of nomenclature of work. It's given here, page 72. Huh? So and so. Which had the approval of the power department. Next one. Agreed by the said corrigendum, comma, the present date petition has been filed at Article 226 of the Constitution of India. Next one. The learned counsel for the petitioner has submitted that the petitioner has completed 90% of the work, and the change of nomenclature at this stage may adversely affect him. Will adversely affect the petitioner. Next part. On a query of the court, comma, the learned standing counsel for the power department has submitted that by the change of nomenclature, no adverse to the interest of the petitioner has been passed till now. So it is also submitted that the said work or a part thereof has not been withdrawn from the petitioner. Next paragraph. Accordingly, the court is of the considered opinion that by corrigendum dated 23/2025, no order adverse to the interest of the petitioner has been passed. So accordingly, the petitioner cannot have grievance with the change of nomenclature of the concerned work, as submitted by the learned standing counsel for the power department. Next paragraph. Accordingly, this accordingly, this petition stands closed as premature because no order adverse to the interest of the petitioner has been passed. Next paragraph. It goes without saying that in the event the petitioner is aggrieved by any adverse orders, it would be open to him to challenge the same. Next paragraph. Stands closed.
All right, sir.
My lordship, since the leading counsel is on the way, so I humbly pray the matter may be placed for the pass over matters.
Made, Lordship. My pleasure. Lordship, here I'm agreed by the process of technical evaluation. Lordship, Annexure 2, page 23, Lordship. This is the NIT.
You see, this only issue remains
Lordship,
is that on the day when you submitted one bid, you also submitted 2 other bids.
yes, 2 other bids.
So now they are saying that since there are 3 bids, this is not technically non-responsive.
Yes, Lordship, on that day I submitted 3.
Now, where is that clause in the NIT? Where is that clause in the NIT?
Lordship,
3 bids.
that clause. Lordship, for easy reference, Lordship may come to para 7. If not in annexure this, it will be, Lordship will get confused because of this document. So for easy reference, Lordship may come to page 9 of para 7. Otherwise, Lordship will find at page 63, the annexure.
Just a moment.
This.
Yes.
Lordship, here.
Each bidder must produce an affidavit, which is the relevant clause.
Yes. I have reproduced that at the annexure 7, the relevant clause only.
Yes, yes. Which is that relevant clause?
Yes. The relevant clause will be, Lordship, section 2, clause 4.4 BA.
4.4 BA.
4.4 BA of section 2.
Okay. Each bidder produce affidavit.
Yes, Lordship.
Criteria, make bidding false statement, record of performance, participate in bidding for the same work.
Lordship may. So it says, Lordship, it must merit. Say each bidder must produce to an affidavit that information furnished with the bid documents is true and correct in respect and such other certificate as defined in appendix 2 IDP. Failure to produce the certificate shall make bid non-responsive. Further, it says 4.7. Even the bidders meet the above qualifying criteria, they are subject to be disqualified if they have made a misleading or false representation in the forms, statement, affidavit, attachment submitted in proof of disqualification, requirement, and or. So, Lordship, if Lordship come to page 188, then this is the bid documents I have submitted. I have given as a nil only because I have to show that works for which already submitted. There was meaning thereby, there was no pending work should be there. That is, Lordship, 1 point. Further, Lordship, if section 3, qualification information, clause 1.3.2,
you are reading where?
Lordship, para 7. Para 7, page 10. Lordship.
Yes.
Now, section 3 says that information of bid capacity, works for which the bid have been submitted, and the work which are yet to be completed as on date of this bid. So, meaning thereby, Lordship, if we give an interpretation to it, now interpretation should be in favor of the petitioner, because this bid already existing or ongoing works or works which have been already been submitted. Now, when I was submitting this bid, there was no pending work. It should have to be harmoniously interpreted, Lordship. Further, Lordship, when may I take Lordship to annexure 8, before technical evaluation of annexure 249 Lordship page. Now, before this all technical evaluation were to be done, I submitted a representation saying that kindly check the work experience of all other firms, Lordship. May I read this? Page, annexure 8, page 249, Lordship.
240.
249, Lordship.
249.
Yes, Lordship. Lordship there, 249, 249. Annexure 8.
Yes.
Yes. To the Superintendent Engineer, IWC BAM, Leparada District. Subject, request for cross-verification of work experience certificate submitted in tender with issuing authority of all the bidders against the work, that is 20-bedded hostel building including kitchen and dining hall with warden room and 4-unit double-story type 2-quarter at GPUS Palm 2. 20-bedded hostel building including kitchen and dining hall with warden room and unit 4 type 2-quarter G+1 at GHS Nari and 3 unit 2 quarter number type 2 quarter at KGB. With due respect and humble submission, this is to request you to seek a written confirmation from the concerned issuing department of the work experience submitted to you by all the tenders. That meaning thereby including me. I have scrutinized against the aforementioned work to refrain from future complication and smooth execution of project. Therefore, you are highly requested to do favor and necessary action, please. Now, may I take Lordship to page 250? Lordship, this is my representation after disqualification. Now, may I take Lordship to annexure 9, 252. Now, one of the firm, the successful firm, Lordship here, is Enterprise. He shows the work of Changlang. However, he is his firm is of Lower Siam. So according to the District-Based Entrepreneurship Act, so this firm cannot work at Changlang. Class 3 contractor, this cannot show the work of the Changlang. And Lordship, if Lordship calls for record, we can see that this is Enterprise is enlisted on 18 February 2021. Now the date of completion it shows 5/5/2020. Now, Lordship, this is that there's overlooked it. So therefore, Lordship, the process of evaluation of technical has not been done properly, Lordship. Now my case is, Lordship, that by nil, it is not a misinformation. If we read all the section on which my firm is said to be technically not responsive, Lordship, it says annexure 3, page 27, 1.3.2b of section 3, read with 4.7 of section 2 and 4.b. It gives a picture that I have misleaded some information. However, if we interpret, Lordship, this, if we closely interpret, the objective of all this is to let me to participate on this, on that work without misleading them. So when I was submitting, obviously, if they have project, they must have project. That information, what I've written, it's in the first tender also. There were 3 packages on that day, 3 NITs. On the first NIT, this is the first NIT. How? Obviously, it will, there is there is no pending work, Lordship. And if they are technically, if the department is saying that this nil is misinformation, they should justify it.
Yes. My Lord, as of today, my instruction that work has been already aborted to successful bidders. And as per this instruction, page 188, this is one of the form which he has to furnish. On the same time, in three packages he have participated, but he should have disclosed that for the purpose of calculation of the bid capacity. Page 1, this format he has submitted as nil, although he participated in three packages. So it creates difficulty for the tendering authority to calculate the bid capacity. Only for that purpose only his bid was rejected. And disclosing that it amounts to misinformation. That is the instruction which I received.
Lordship, let's say for argument's sake, if we say that we have written submitted, how does it change the nature of the contract, Lordship? Whether my bid capacity will be shown by that, yes, I have given this, I have mentioned or I have not mentioned, Lordship. And in all three NITs, I have submitted same documents. In third NIT, they keep me as a technically responsive, Lordship. In two, I am not responsive in these documents, and in one, I suddenly becomes responsible, Lordship. The whole, Lordship, that's why my case is, Lordship, is on the process of this evaluation. It's totally arbitrary, Lordship. And
where is your statement that in two other bids you were held to be responsive?
Lordship, for para 11, Lordship, I have said that I have at the time of that I have not mentioned it in this petition, Lordship. However, I have given info. I have said that in two other I have submitted in this one. In other two also I have participated. Para 11, Lordship. Lordship, if records may be called for it, we will get a very good picture, Lordship. Because we cannot obtain all these documents from the department also.
What is the date when you submitted this bid?
Yes, Lordship.
What is the date when you submitted the bid?
Date, Lordship, 18/3/2025, Lordship.
18/3/2025.
Yes, 18/3.
Can you come to page 103?
Lordship. Lordship, yes. This is the bids document I have submitted. This one, this all annexes.
You see, this date of making the banker check is 15/3. Correct?
Yes, Lordship.
So that means you see, you are aware that on a particular date you are be submitting three bids because every bid will contain some deposit.
Yes.
And this is procured 3 days in advance.
Yes, Lordship.
For submitting on 18th.
Yes.
Therefore, on that day, 18th, that you will be submitting three bids.
Yes, Lordship.
Is a fact which is known to you.
Yes, Lordship.
And when you are saying that in the first bid was rejected and in the other two bids you are held to be responsive.
Yes.
That means they are now taking that you have only two bids, not three. And therefore you are held responsive in the two bids.
Lordship. Yes.
But there is some logic in their action.
That's why, Lordship, when I was submitting, I have written nil. I'm not trying to justify that why I've written nil. It was in my understanding that when I'm submitting three on the same date, then for me, the interpretation was that works which I have already submitted, not submitting, Lordship. That was my interpretation. It may be wrong, Lordship. It may be wrong. But the process that evaluation, then why only me? When successful the bidder, his documents were not scrutinized, Lordship. The process, that's why Lordship, I'm saying the process of evaluation. Now, I'm not challenging the outcome of evaluation, Lordship. I'm challenging the process. That entire process should be.
No, that would not be. That would not be permissible. So please come to page 17. You're not asking for the rejection of the bid of any of the bidder. That is not your prayer. So therefore, we can't inquire with regard to that. Yes. With regard to the bid submitted by this person who you say is not registered for your district.
Lordship, here, set and quest aside the impugned minutes of technical bid evaluation. Lordship, may I place this one judgment also, 2024-10 SCC 273?
Yes.
This.
2022-10 SCC.
Yes. 273, Lordship.
273.
273. Lordship, may I take you? I have flagged my Lordship.
Yes.
May I take Lordship to this para 9, 29. So 29-30.
Yes.
May I read? Government bodies being public authority are expected to uphold fairness, equality, and public interest even while dealing with contractual matter. Right of equality under Article 14 avoids arbitrariness. Public authorities have to ensure there's no bias, favoritism, arbitrariness are shown during the bidding process. So, and that the entire bidding process is carried out in absolutely transparent manner. So my Annexure 8 says that it has been transparent. They have not done it. Annexure 9, where the work experience is source of the Changlang note of this Lower Siang Lordship. Further Lordship, page para 31. In Sterling Computers Limited versus MN Publication Limited, this is 1993 1 SCC 445. The court, while dealing scope of judicial review of award of contract held, while exercising the power of judicial review in respect of contracts entered into behalf of the state, the court is concerned primarily as to whether there has been any infirmity in the decision-making process also. In this connection, we reference may be made to Chancellor. The purpose of judicial review is to ensure that individuals receive fair treatment and not to ensure that authority, after according fair treatment, reaches out the matter which is authorized or enjoined by law to decide for itself a conclusion which is correct in the eyes of law. That's why I'm telling the entire process of evaluation. I'm even after re-evaluation, Lordship, if I'm not responsive, it's okay, Lordship. But the process, it should have been fair, Lordship. By way of judicial merit for the Lordship. By way of judicial review, the court cannot examine details of the terms of the contract which have been entered into by the public bodies or the state. Court have said by the House of the Lord in efforts is Chief Constable Police versus events. The court can certainly examine whether the decision-making process was reasonable rational, not arbitrary, and violative of Article 14 of the Constitution. This is my case, Lordship.
We'll have to issue notice in this matter. They are alleging respondent number 6 to be disqualified. And they are also saying in paragraph 15 that in his list of engineers, he has given a name of one person who is already a government servant.
Yes, Lordship.
If that be so, then it's if he is allowed to participate in the process, it would still be bad.
The respondent number?
Respondent number 6. The last page of the writ petition is annexing a document. Is saying that this person was shown as his technical person, but he is employed with the state.
That part I have to take instruction.
You'll have to issue notice in this matter.
Lordship, I'm praying for this interim also, Lordship, because Lordship, I'm ready to bear if there is any change in cost, Lordship, if I'm successful, Lordship.
Well, the project is for construction of school building. So if the work is delayed,
No, but if you have selected a person who is already whose technical person is a government servant,
Lordship,
then it will be illegality.
Prima facie, Lordship, is very illegal, Lordship.
We'll give a short date.
Lordship.
next week. Then
Till then, you don't finalize the work.
Lordship.
Otherwise, work order is already issued. Work order is already issued. I am told.
Is already issued.
Yes.
Already issued, but not executed.
Where is that?
No, verbal instruction. Yes. This morning I have called.
It was issued when? Can you find out? Can you?
Next day?
No, we'll take it up after some time. Just get the instructions when the work order is issued.
Yes.
After some time, we'll take it up.
Hello.
Yes. May your lordship, please. Here in this case, we are having one WPC that is 195 of 2025. It was filed. Well, the recommendation was made by the tender evaluation board members to the deputy commissioner. Then, during the pendency of that, again.
Just a moment. Mr. Naran.
Yes, my lord.
In this contract, or in the sorry, not the contract, in the tender notice, where is the clause that shortfalls can be condoned? In the NIT or in the tender document, is there any clause that if there is a shortfall in the tender, then that can be condoned?
Well, that specific may not be.
Please come to page 48.
Correct. 48.
Page 48, last paragraph. After examining the documents, so-and-so is found to be with minimum number of shortfall.
The lordship is taking up the, my lord, 48, that board proceeding, my lord.
Huh?
Board proceeding,
Yes.
my lord. Yes, my lord.
Page 48.
Yes.
Last paragraph. Is found to be with minimum number of shortfall.
My lord.
But if that is so, then if there is no clause in the tender,
One five. Page number. Security deposit masim. The relaxation, what the lordship is asking.
Relaxation is not. These terms and conditions are illustrative, not adjusted, and any other terms and conditions may also be included. That is what they say. I think we have the gracious indulgence of my lord for 1 minute.
Yes.
Lord, just two documents, Lord. I'll show that this read petition is not mentionable and it should be dismissed in limine itself, Lord. For the reasons that the registration, Lord, kindly talk about. Lord, kindly come to page 55 for a election 3.
55.
55. Type 40 is at page 56. This is not the government of Arunachal Pradesh, Office of the Deputy Commissioner of Publication District, Demi, it's inviting tender. The first paragraph, we invite seed tenders from the interested cooperative societies of Publication District, my lord, kindly know. But the farm kindly come to page of the 57 thereafter. Page 58. Well, kindly come to page type copy. Lecture 4.
Yes.
This is to certify that under Section 9 of the Arunachal Pradesh Cooperative Societies Act 1976, Act number 3 of 1979, A cooperative society under a name and style in Nanyo multi-purpose cooperative society Limited, PO Pigeon East Coming District Arunachal. Nothing less, nothing more. So that's subsequently. So therefore, my lord, a cooperative society of East Coming District will not be able to participate in publication district.
Here, Mr. Patel. We'll hear Mr. Patel on that. Mr. Patel, the objection of maintainability is raised.
Can you see, my lord, page number 59?
59.
Yes. This is to certify that the Nangyo Nampin Multipurpose Cooperative Society Ltd District Pakikesa, State Arunachal Pradesh, has been registered by Gov Order such and such, has duly renewed its validity of the registration renewal for a period of 3 years with effect from 13/8/2024 on deposit of rupees 5,000. See this, my lord. Because Pakikesa was carved out from East Cameng, where newly district was born. And before the bifurcation of the district, I ran this business. And even here also, in the case, Pigirang is Cameng district. Where is Pigirang located? Pigirang falls under Pakistan district. So it was a decision was done prior to the bifurcation of the district. Pakistan is newly born district. And cover program is Cameng district. And this baseless argument, we never expect such a topic to submit such a submission before the court.
The sentence is flying very high, which I did not expect from the Pitama of the bar to that extent. Whether I am deserving or not, that is another thing. Then of case 959 itself, it clearly indicates that nothing has been mentioned about the operation. If the senior counsel can establish that the renewal is subject to the operation of the Pakikesa district, there is something different, page 59. We understand the predicament, the level of discourse must be very high, the rate of the individual capacity representing any parties.
No, but this document sustains the what you call the maintainability, because this is Pakikesa, and the East Cameng district has accepted it.
My lord, is the ground for rejection of my tender paper by the evaluating committee of the board members? Is the ground? Did they ever mention it? Did they reject my tender paper on the ground of this, as alleged by the learned advocate?
Sir, do not take it personal.
No, it's not that.
Not take it personal.
Not personal.
No,
but he's making a submission before the court. He's not attacking you.
Very wrong.
But kindly see.
His submission is about the board member of board evaluation committee.
I have to refer to the Halsbury Law of England dictionary. The word learned advocate, you read with the 1861 Advocate Act. He is not a person standing as an individual capacity as an officer of the court. So therefore, my lord, there must be a great humility and sense of respect, irrespective of the age, my lord. We are learned
No, that's okay,
officers of the court.
That's okay. But the objection is not sustained. Yes. Mr.
Therefore,
Patil.
that I request, Patil sir, let us know. Others, you can say the learned.
No, that's
or
okay.
something else.
We are hearing it. Mr. Patil,
Yeah.
what are the other grounds of challenge?
Ground of challenge is clearly mentioned here, my lord. Para come to para 20. Para 13.
I'll just take a short break and come back.
Page 18.
Just a moment. I'll take a short break and come back. Just take
Yeah. The petitioner Battery stated, after going through the information received from RTI, the following defects were found in the bid of private respondent. That as per the term and condition of clause 4.1, the earnest money of ₹2 lakhs only in the form of deposit at all receipt oblique fixed deposit received in favor of the Deputy Commissioner Packet Kesang District. The earnest money will be refunded on finalization of the tender. Now, the private respondent number 7, M.S. Papu Hate, Multi-Purpose Cooperative Society has not deposited earnest money of ₹2 lakhs only in the form of deposit at call receipt oblique fixed deposit received in favor of the Deputy Commissioner Packet Kesang District. The Tender Board Committee has illegally accepted fixed deposit receipt of ST Enterprise. ST Enterprise is a different legal entity, and Papu Hate Multi-Purpose Cooperative Society different legal entity. And Papu Hate Multi-Purpose Cooperative Society was the firm who has participated in the tender. ST Enterprise was not the party to the case. And come to the page, my lord, come to the page 70. Page 70. Here they have deposited Packet Kesang account ST Enterprise. It should be deposited in the name of Papu Hate Multi-Purpose Cooperative Society. It completely violates the term and condition of the tender. Thus, the clause 4A, term and condition has not been fulfilled by private respondent board. Now come to the second. Yes. Now, second, that as per term and condition, or as clause 4.2, the tender bidder has to file financial soundness certificate from a nationalist bank, mentioning the value of contract and that the tender is capable of undertaking for a minimum amount of 50 lakhs as per category. In response to class 4.2, the respondent number 7 has submitted insolvency certificate from Arunachal Pradesh State Cooperative Apex Bank, whereas the Arunachal Pradesh State Cooperative Apex Bank is not a nationalized bank. It is a state cooperative bank of State of Arunachal Pradesh. Despite being known about the fact, the respondent authorities accepted favoritism to the private respondent, and in the evaluation of this, it was probably remarked as issued from ICICI Bank. Thus, the private respondent has not fulfilled the mandatory condition under clause 4(2). Now, there is annexure 73, my lord. Instead of page annexure 11, page 73. Instead of nationalized bank, they have found certificate from Arunachal Pradesh State Cooperative Apex Bank. So this is also here also. They have completely violated. That 3, my chapter 4(3), we forgo it because after we file the petition, they have supplied the copy that they have obtained NOC from SBI, Arunachal Pradesh Cooperative Apex Bank, UCO, Vijay Bank, UBI. That as per term and condition of clause 4(4), the tenderer has to submit income tax clearance certificate, income tax exemption certificate, as the case may be, but same has not submitted by the private respondent. How this is the term and condition of the tender when it is clearly violated? It's part of the how it was overlooked. However, by showing favoritism and violating term and condition of the tender, the bid of private respondent has been accepted. Now, come to the part that as per term and condition at clause 4(7), details of vehicle owned by the tenderer along with attested copies of registration certificate and road permit minimum 4 truck or attested copies of the lease agreement executed before a magistrate minimum 4 truck with attested copies of registration certificate and road permit with tax paid up to date. In terms of clause 4(7), the private respondent has sold 4 vehicles hired from neighboring state of Assam, but the 2 vehicles, such and such, were not permitted to carry goods in the state of Arunachal Pradesh except state of Assam. The road permit submitted by the private respondent is from Assam, state of Assam. Thus, the requirement of clause 4(7) has not been complied and undue favoritism has been shown to private respondent number 7, and it is the evaluation. The evaluation, it has been arbitrary and illegal shown as valid. Now, there is annexure 12. The road permits are from Assam, only Assam. They can fly only in Assam. When the road permit is not confined only in Assam, how they can carry the PDS commodity in Arunachal Pradesh? That 6. As per term and condition, at clause 4(8), a copy of business turnover certificate from RCS that the society has been running business turnover of at least 1 crore in last 3 years original. 3 years original. In terms of clause 8, the private respondent has not submitted any business turnover certificate from registered cooperative society, nor the requirement of 3 years as mandated has been fulfilled. In fact, the private respondent number 6 was registered only on 21 to 2022, my lord. Here in the tender, the condition is required there, they require 3 years. Whereas 21 to 2022, it was 3 years. This tender was called 2024. So from 2022 to 2024, it will never be a 3 years. So my contention is that he is not qualified as per term and conditions of the tender, and not completed 3 years as a cooperative society. The financial year of
Mr.
private
Patel,
for number 6 as follows.
Mr. Patel, you see, please come to page 82.
82.
Yes. This registration certificate is of Papu Hote Multipurpose Cooperative Society. Correct. Now, this registration certificate shows that the area of operation will be Pake Kesang. Area of operation is Pake Kesang. Page 83. This is also area of operation is Pake Kesang. Page 83. Come to page 84. Again, this is Pake Kesang. Correct. Is there any similar document with you referring to your this registration certificate saying the giving the area of operation?
Yeah.
Because in your writ petition, you have not said anywhere. In your writ petition, you have not said anywhere about the area of operation.
Come to the 59, page 59, renewal certificate. This is to certify that the Dangyo Nampi Multi-Purpose Cooperative Society at the district publication, state of Arunachal Pradesh, has been registered by such and such and such, has duly renewed its validity of the registration renewal.
Doubting this page, we are not doubting this page 59.
Then come to my
But
lord.
when you are annexing document of the respondent 6,
Experience, my lord. 130, my lord.
just one, I'll come back to you. I'll come to you.
130.
Because when you are annexing documents,
Yes.
that means the registration.
Yes, my lord.
This is the manner of issuing a registration
My lord,
certificate.
135. This is to certify that MS Namyo Nampin Multi-Purpose Cooperative Society, LTD, Pijirang of Pakistan DC, was appointed as district PGS such and such contractor for period from 1/4/2016 to 31/3/2018 and carry out PGS contract work with tune of rupees 2.26 crore amount very successful. 135 page. Then my lord, 134 also. This is to certify that NN Multi-Purpose Cooperative Society LTD has been doing as district PGS carries contractor of respect of Pake Kesang district for the period from 2022 to 2024 successfully. Then
No, Mr. Patin, I am referring to these documents to show that the area of operation, there are the government of Arunachal Pradesh issues a certificate with regard to the area of operation. Now, is there any such document with you defining the area of operation?
all the certificates are covering the area. 35 is also covering, 135 is covering, 134 is covering, and covering my lord, and come to the my lord, another 131. Come to the 131. The above appointment shall remain valid up to 9 months, 1st July 2024 to 31st March 2024. This is also my firm, my lord. This present applicant, MS Nangyo Napin Multi-Purpose Cooperative Society Ltd Pakistan, as PGS District Land Route Carriers Contractor of Pakistan District, Lemni of AP, for post deposit procurement, roll, lifting, and transportation of food grain rice only for 9 months. 1/7/2024
That's not the, that's not the
31/3/2025.
question. That's not the question. You see, you are next to three documents. Which page was it? I forgot. The page 58.
Where?
It says area of operation.
Where? Page 58. This is the registration certificate.
Area of operation is
Yes,
Kamen
this is
district.
my lord. It was done before the bifurcation of the district because they were same district. Pakistan was part and parcel of the East Kamen district. This registration was done. And only this 3 years is running this Pakistan district. After carve out from the East Kamen district.
Okay.
We're in the same district, my lord.
Okay.
Now only it becomes 3 years separated from the East Kamen district. So now my area is fall under Pakistan.
Okay. Okay, yes. Mr. Navam, then we come to Mr. Tara.
My lord,
Yes.
has your lordship got in my 58th? My lord, now this confusion will come out. This is the registered certificate issued on 13 August 2009, my lord. My lord, this was issued when, my lord, there was no any bifurcation of new district, my lord. That is application, my lord. If your lordship see the down below, my lord, there is nothing wrong because it says, my lord, the validity of registration is up to 13/8/2012. Has your lordship got it, my lord?
Yes.
Yes, my lord. Down below, if your lordship sees, the area of operation will be confined to entire East Kamen district in Arunachal Pradesh. Nothing is wrong. And this was issued by the Registrar Cooperative Society, Malana. Now, something went wrong. If you see the language, if you lordship in renewal, my lord, that is next page 59, my lord. This is the renewal that is 24 December. Now see the authority is different, my lord. This is the government of Arunachal Pradesh, office of the...
Just a moment. Page 59.
Yes, page 59.
Yes.
This is dated SEPA 24 December 2024. If your lordships see the other the authority, my lord, that was issued by the registrar Naharlagan. Now, this is the assistant registrar of cooperative society, East Cameng District SEPA. Has your lordship got it, my lord? Yes. My lord, now the very certificate has been renewed, my lord. If your lordship see, my lord, this is to certify that the Nyamtin Multi-Purpose Cooperative Society Limited, District Pake Kesang, Arunachal Pradesh has been registered by so number, has duly renewed its validity of registration renewal for a period of 3 years, with effect from so and so, deposit 5,000, so and so. But here, my lord, well, in renewal, my lord, they have not made out the mother area, my lord. They have not demarcated, my lord, the operation, my lord, of area of operation, my lord. As your lordship, my lord, in previous, my lord, area of operation very clear, my lord.
Tell me.
But one thing, my lord, but
No,
not.
but just tell me. Let us say that I'm not aware of the geographical location, so excuse me for that. Let us say a place A.
My lord.
It falls within the district of, say, Papumpara. And can it renew the registration certificate of B, which is, say, in Lower Siang district?
My lord.
Can the authority
Cannot. My lord. Why this happened? Because now Pake Kesang is a newly created district, my lord. Perhaps there is no any authority called my assistant registrar of cooperative society. So this was based in SEPA, my lord. So that authority was given to him, my lord. So, well, renewal, my lord, I don't see, my lord, any discrepancy except, my lord, the area of operation has not been marked out. But the facts remains, my lord, that the operation area will be Pake Kesang, my lord. There is no doubt about that, my lord.
Okay.
That's exactly what I was trying to share, my lord.
Okay.
Otherwise, your lordship is correct, man. How come, my lord, is coming authority can issue the certificate of Mala Pake Kesang? He cannot, man. Because there was no operator was available because of new district, my lord.
Okay. But then the tender...
Rest, my lord, if your lordship sees, my lord, the minus of the, my lord, board proceedings, your lordship was referring, your lordship was asking, my lord, is there any specific terms and conditions?
Page 48.
Page 48, my lord.
Yes.
Yes. My lord, if your lordship sees, my lord, the successful bidder is serial number 3, my lord, Papu Hatem. Now, the both proceeding, my lord, they have come to a conclusion, my lord, based on their, my lord, documentation and performance, my lord. If your lordship see, my lord, the petitioner, my lord. Petitioner is serial number 2. Has your lordship got it, my lord?
Yes.
This is NNMPCS, my lord. Now, when you see, my lord, the comparative, my lord, between the petitioner and respondent number 6, my lord. Now, petitioner number has 1, 2, 3. There are 3 major defectives which board proceeding they have identified. Whereas so far, my lord, respondent number 6 is concerned, my lord, only one truck that insurance which got, my lord, expired on 3/1/2025, my lord. My lord, this is the board proceeding observations, my lord. When you see, my lord, this board proceeding, my lord, they are, my lord, whatever recommendation, my lord, nothing is wrong, my lord. They have, based on the documentation given by all the parties, my lord, all the bidders, my lord, well, scrutinizing, my lord, they have come out, my lord, who has, my lord, major defaults, my lord. Accordingly, my lord, after examination of document of above mentioned firms, MS Papu Hate MPCS Limited is found to be with minimum number of short sports, my lord. So that sort of comparative, they have drawn it, my lord. Your lordship was asking, my lord, is there a specific terms and condition for giving any relaxation, my lord? My lord, I have just checked up. My lord, there is no any such terms and condition which authorize, my lord, the board proceeding. But what we have to see, my lord, the the fairness, my lord, of the proceeding of the board, my lord.
No, my lord, I have
No,
just a moment, just a
Acha.
moment. Let the additional advocate general complete.
Then, my lord, if there is any like shortfall on the part of the private respondent, my lord, they could have raised before the board, my lord. That was never brought before the board proceeding, my lord. Subsequently, they might have lodged a complaint to the deputy commission. That is altogether different, my lord. But during process, my lord, no one raised any objection, my lord, saying that private respondent does not have, my lord, EMD, does not have validity, does not have income tax clearance, insolvency certificate has been issued from the, my lord, non-recognized, my lord, bank. So that sort of was never brought to the board proceeding, my lord. So that's why, my lord, the observation is very clear, my lord. They've compared with all the documents. They found it, my lord, respondent number 6 to be least defective, my lord. That's why, my lord, his name was recommended, my lord. If the Learned Senior Counsel can show any, my lord, documents raising any sort of objection, my lord, during the board proceeding, my lord, then, my lord, yes. But so far, my lord, complaint to the deputy commissioner is, my lord, that is afterthought, my lord. After both proceeding was over, recommendation was done, my lord, then only, my lord, they lodge complaint. If your lordship see, my lord, see that, my lord, that, my lord. Board proceeding date is 10 January, and the petitioner is lodged the complaint on 23rd January, my lord. So almost after 20 days, my lord.
No,
13 days.
Come to page 64.
My lord, December 20 met on 10 January 2025, my lord. So both proceeding was done on, my lord, 10 January, my lord.
Yes, yes. Come to page 64.
64, my lord. No, this is by the petitioner, my lord, to the ADC.
Correct, but the allegation here is that on that day, the documents were not scrutinized.
My lord, this, my lord, why I'm saying this cannot be, my lord, accepted because there is no any receipt from any sort of authority, my lord. This could be, my lord, manufactured document, my lord. Why I'm saying, my lord, because there is no any acknowledgement given by any authority, my lord. If your lordship is referring to 64, my lord. This is 16 January 2025. Yes, ma'am. And I chair 5, my lord. I'm of the party which is the tender document. Yes. What side? ये तो ठीक है. It was opened on 10 January. Unreadable. And see you represented 33 after 15 days. Actually, I'm not. My lord, in the tender process, my lord, we all know, my lord, what is the role of EMD, my lord. It's placed the, my lord, heart of the tender documents. The Land Exchanger Council was going to, my lord, page 70, my lord. EMD, my lord. Page 70, my lord.
70, yes.
Yes, my lord. Type copy 71. The type copy will be more clear, my lord. But what exactly the Land Exchanger Council was raising, my lord? This HT Enterprises, my lord, he is not a bidder, my lord. The bidder is who is, my lord? That is, my lord, Papu Hote is the bidder, my lord. But what is important is that, my lord, the money has been deposited in Deputy Commissioner account.
No, if a tenderer, can I not think or presume that a tenderer who cannot make a call deposit of 2 lakh rupees?
My lord, that part, my lord, yes, my lord, I had a talk with the officers, my lord. Perhaps they have overlooked these things, my lord, this HT Enterprise, EMD, my lord. What they have focused, my lord, more the security EMD has been deposited, my lord. My lord, before I conclude, my lord, the instruction given by the district administration is that, my lord, the work has been awarded, agreement has been drawn, and this March month, my lord, they have already lifted and they have supplied the things, my lord. My lord. The response number 6, my lord. That is the latest status, my lord.
Okay. Yes, Mr. Karan.
Well, I will still insist on page 58 and 59.
Yes.
Milord, that in the registration, Milord, 13 August 2009, the area of operation has vividly been mentioned, Milord. The second aspect is at page 59, Milord.
According to you,
yes, Milord.
This cooperative society registration is valid for how many years?
3 years.
3 years.
3 years.
Yes.
Milord, kindly come to page 59.
Yes.
Still, I reiterate, Milord. The area of operation has not been mentioned, Milord. Whether you were bifurcated from East Cumming district and you are having a separate entity. Milord, it is by an enactment of the State Assembly, a District Reorganization Act is separate. And it is your duty, Milord, the moment you come to know that I am bifurcated from East Cumming district, you should make an application to the registry of the cooperative society by convening a general body meeting of the corporations adopt that since although we have registered here, our registration instead of East Kamen may be shown as Pakikesan district. And also our area of operation has to be in this. So they have not done it, Lord. So therefore, unless you don't precisely and crystal clearly mention the area of operation, still the maintainability issue looms large on the petitioner, Lord. This is the one solid ground. And then, Lord, I may have little difference of opinion with the learned additional AG on one count, Lord. The person who has registered, who has renewed at page 59, Lord, is the Assistant Registrar of Cooperative Societies. And Lordship was correct, putting a question, can a district A be officer, can renew the license of another, the district B? The answer would be no, Lord. As
I don't
because
know.
it is a jurisdictional issue, my lord.
Since the day I started my trust with law, I have always read section 114, illustration E.
Evidence Act.
Yes.
Yes, again,
It
correct.
says all official and judicial acts are duly performed.
Well, that objectivity, my lord, I do appreciate, my lord. And I respectfully accept the view as well. But at the same time, my lord, kindly appreciate the jurisdictional aspect of it. Because the jurisdiction is very clear. He is from the...
No, you'll have to move a separate writ petition, ask for termination of the service of this official.
That part, my lord,
Assistant Registrar of Cooperative Society. If he has passed an order, he is good enough.
My lord, confusion, my lord, which has come up, that can be clarified if I take instruction from the authority, whether there is a specific Pakikesan assistant registrar is there or not, or he has been given authority to exercise that or not.
No,
that
you see, you see, an act done. Can it be undone now? Let us assume that the authorities say that he did not have jurisdiction.
If done without any authority, my lord, then my lord, that should be known as in the eye of law.
Correct.
No, the authorities will have to revoke this certificate.
Yes, ma'am.
Till the date this is there and not revoked by the government. You can't say that the effect of revocation is not there. Now let us say that one of your peon in one of the department issues an appointment letter. Then what does the government do? They have to say that the appointment is illegal.
Suppose, my lord, if the is coming SAPA has been authorized, my lord, to renew, even for the Pakikesan, in the count, my lord, that renewal nothing is wrong.
That's why we ask. Yes, you see, that's why I'm giving a horrible example. If a person having no jurisdiction, if a person having no jurisdiction makes an appointment, then tomorrow you will have to come up and say, the government will have to come up and say that the appointment is illegal, we don't recognize it. It's nobody's case that this is without jurisdiction.
Now, the question of jurisdiction has come up, my lord. Now, whether this assistant, my lord, the registrar, whether he can renew the certificate or not, my lord.
Cooperatives are
That's why, if he has been authorized to do that, my lord. Otherwise, my lord, he cannot. I agree to my friend, my lord. But suppose if he is authorized, then.
Well, immediately I forgot that judgment, 2008 judgment. Well, there is an judgment by the Appeals Court in 2008 which says void or irregular order cannot be held to be void ab initio unless it is put into challenge and cured through the judicial course.
Yes, Mr. Tara, I can make your work short.
Yes.
This is the website of our cooperative department.
Andhra Pradesh, yes.
It does not have Pake Kesang as assistant registrar is not there.
Okay. So
Check
let me
out the
add for
list.
it, ma'am.
It's not there.
But then the confirmation is required.
Not required. Not required.
Paki Kesang, I know, I am from that district. There is no assistant registrar.
Then you don't know. That's why I said 116 illustration E and in the BNSS, what do you call it? New Act. Bharatiya Sakshya Adhiniyam, I think it should be 119 E.
119.
Huh?
119.
119.
Yes.
Huh.
In any case,
Yes.
I am keeping my option open on this particular aspect.
Yes, yes.
In view of this, without specifying, let us assuming not admitting at the moment that Paki Kesang does not have the assistant register cooperative society, but SAPA has the jurisdiction. In that event also, Milord, the area of operation must be mentioned very vividly. This particular aspect is absent in this. Now, I am coming to, well, there is always one judgment which I always used to refer whenever there is a tender case, That's our 2008 to GLT, page 564.
What is the citation?
2008 to GLT 564. There is one particular paragraph.
What is the name of the parties?
Larsi M versus Meghalaya Tourism Development Corporation Limited.
Okay.
That's always I refer 3 lines from that particular judgment.
Yes.
It says, a breacher is rather found in a browser. The petitioner must succeed in his case on the strength of his own case and not on the weakness of opponent. Therefore, the petitioner itself did not conform to the building criteria and should have been disqualified at the EY stage. Now, this is a reference to the Ronak. Now, here, Milord, kindly come to their bid documents.
2008 to GLT 564.
2008 to GLT, my lord. Para 40.
14.
Yeah, but we I have just called it here. The sentence which I have referred to. The bottom in para 14 makes the bottom 3 lines.
You've seen that?
Yes. So therefore, my lord, kindly come to the impugn order. Impugn board proceedings. Page 48. Terms and conditions are come to.
Okay.
Yeah. Therefore, my lord, kindly come to page 48.
Yes.
I'll start with number 2 only. First, the farm ought to have, my lord, fulfill the tender criteria. The requirement was 4 numbers of truck, and you have come out with the 2 numbers of dumper, tipper, my lord. Dumper tipper is same, my lord. Are sir is correcting me, my lord. Now that is, my lord, how one can load in the dumper, my lord. Then, my lord, page 112, my lord, kindly come. The terms and conditions, my lord, for a moment.
Page number?
112. I am demonstrating from the records of the clause 7, page 1112. Details of vehicles owned by the tenderer along with the attested copies of registration certificates and road permission. Minimum 4 trucks, my lord, kindly mark this. Minimum 4 trucks or attested copy of lease agreement executed before a magistrate. Minimum 4 trucks with attested copy of registered certificate and road. My lord, what he has done online, offline, my lord. So therefore, it could not be verified. Where is
you and he are standing on the same footing. Your road permit is not there, which was overlooked.
Road permit is there, my lord, only for Arunachal. What has happened is, my lord, that the district, I belongs from that district. Now from FCI Godam, my lord, to that Pijiring, Sejusa and Dising Passer, my lord, is via Assam only. So therefore, Dising Circle is under the requirement of that. Truck has a permit, my lord. Assam permit is there.
Assam permit is not there.
Yes. No, 2 trucks I have. 2 trucks, 4 is the requirement, my lord. And the petitioner firm, my lord, has not met with the requirement. Instead of truck, you gives the dumper name. And the insurance is not there. Without insurance, my lord, that road permit, my lord, for one time under Motor Vehicle Act, it is always granted, my lord. No issue, my lord. For one time it goes. And from Arunachal we have 2, and from Assam we have 2. But in their case, my lord, it is not a case of trucks, my lord. Well, one has to fulfill to sustain the argument, to sustain a writ petition, my lord. And, my lord, another ground that I urge before my lord is the lease agreement was to be executed, my lord, before a magistrate, whether it is an executive or the judicial magistrate. But there is one case which I have argued in the division bench of this High Court, my lord, that judicial magistrate has no role, but executive magistrate has the power. So here, my lord, the condition is that they have executed their lease in the notaries, my lord, not before the executive magistrate. Now, therefore, my lord, the basic foundation of any tender matter, my lord, and its paraphernalia argument is that you must first fulfill the tender condition. And, my lord, that V.S. Joshi judgment, my lord, 2005. I'll provide that judgment. So therefore, you cannot try to swim on my soldier. First, you stand on your foot firmly, come with the clean hands, ascertaining that I have fulfilled the conditions, then you can assail me. My lord, kindly see, my lord, see in his documents only, my lord. Number 2, see the fair price of eaters of Sejusa and the Simpas of Circle submitted complaint white letter number against the firm for less delivery of rice, like 38 kgs, 35 kgs in place of 50 kgs in bag, and not to issue NOC, my lord. So therefore, my lord, therefore, my lord, the board, instead of going all these infirmities, has kindly seen, my lord, in the note, my lord, in the note, my lord, in the same page 48, in the note, my lord. The board, it has strictly prioritized on vehicle and godowns only. They understood. And my lord is also kindly aware that tendering authorities are the author of the tender. And they are the best person to adjudicate and decides whose bid is technically viable, who is not. So therefore, by applying a proportional, that is a level playing field has been invoked here. Thereby, without going into all those conditions, they have strict on 2 conditions. So therefore, that page 58 and 59, the jurisdictional part, area of the operation, even was not raised. It is during course of our argument that we are stressing on this one. And in my case, except for one, and there is a separation of materials. And they have not enclosed the lease agreement of the vehicles. So therefore, there appears to be some infirmities which, with great respect and restraint, I may say the word clean hands. Even on deeper examination of their lease documents, even the insurance documents of their vehicles have not been enclosed. Therefore, my lord, in my humble and respectful submission, my lord, I do not find any infirmity. First, you have not approached this court firmly on your own merit, and you are trying to swim over me and seeking relief. And this proposition, my lord is well aware, which I need not to cite any authority. And my lord, one more thing, my lord, I want to point out. No due certificates we have, we will submit it everything. My lord, which the respected senior counsel was forcibly submitting was that why the 2 lakhs deposit for. My lord, kindly page 158 terms and conditions. My lord, kindly come to.
Is the terms and conditions of tender available here?
Yeah.
Yes.
Where is that?
Yeah.
115.
115.
11?
I'm given here, man. I have copy and 111. 110, madam. If your lordship taking up 110, yes, 110.
110. Type copy 110, yes.
Yeah.
Tender terms and conditions. Well, I'm concerned with, clause 4 of the tender. According to them, the tender should be submitted in printed letter paid, indicating clearly the name of the proprietor. Here, in my case, I have given the name under my proprietorship with full address and telephone numbers of the tenderer, along with all supporting documents as mentioned. It does not say anything about this nationalized bank or this or that, but it says you must submit, the two checks, deposit, call receipt.
Okay.
Therefore, it is up. Can we come back at 2, I'll place 1 or 2 authorities. Okay. Now, that earnest money thing, which will see at page elected page 1111 is I fulfill this criteria. Then solvency certificate, that is page 19 and 20, elected 11, page number 73. That also I have fulfilled.
The second one you don't fulfill. Nationalized bank is not there. It is cooperative bank.
Correct. And no due certificates, Can we come to page? No, that is according to their. That is, they have annexed, which we have fulfilled, clause 4.3, we have fulfilled. It is, we have with us, and it is with us. This is a false allegation. And
your income tax exemption certificate is not there.
But it is there.
Your road permit is not there.
Our is there.
Hmm?
We have. Income certificate is not there, but rest of the documents is there.
No, it's not there.
As the case may be, In the terms and conditions, kindly come, as the case may be. 4. 112, page 112, kindly see.
We've seen all these conditions.
Yes, in the event of 2 registered cooperative societies containing similar rates, documents, preference will be given. 12. Yes. So that's what I'm writing. And here, it is already there, page 112. We have, they have annexed themselves. We have fulfilled those criteria. Even in the white clause 7 of the tender deeds, details of vehicles owned by the tender along.
We will examine in past orders. And incidentally, that since you always refer to English laws, you check up with the Oxford Dictionary. Incidentally, you will find tipper is a large truck as per Oxford Dictionary. I think
Tipper.
As per Oxford.
But the definition would be.
I don't know.
One thing, but the structure of the car, the structure of the vehicle that is used for a different purpose.
Whatever be, but it is this. Show me the. We don't have Oxford Dictionary, no.
My younger has made out a definition Or from dictionary, difference between the tipper and throttle.
No, that we don't know, but
It says on key difference is
yes,
that tipper.
even
also
this will
known
have
as
it.
Dump truck.
You come to this. This is a thesaurus. Yes, showing this. This page 1082. Tipper is a truck.
People they have submitted. It's not by us.
This okay, but
Which one, Lord?
tipper.
So, tipper. A lorry with a rear platform which can be raised at its front end, thus enabling goods to be unloaded. A person who lives at 3/4 space feet amount.
So that's tip, but
There's a dumper they have said. The dumper, they have said dumper.
tipper.
No,
They said tipper.
No, they said. Sorry.
They said tipper.
They said tipper.
Well, kindly see.
No, I don't know. I just since you love those, I've just shown you from that Oxford.
It says the literal meaning: a lorry with a rear platform. It is. So
What will be? I'm not on those.
Which can be raised.
I'm not on those specific. But it is a truck. You check in your Oxford dictionary. You'll find it.
I'll find it. Not an issue. Well, I wish not to quarrel on this point.
No, you're not buying this.
Well, that small packet dictionary that used to be there during my student days, I used to make it sure that I'll carry that. I'll read throughout the day.
It's okay. I'll pass what is in chambers. I'll just examine it.
Fine. Great.
This is item number 2 and 3 are same.
Correct. 2 and 3.
2 and 3 are same.
2 and 3, same.
Okay. One case, my love, 95, WPC number 95, reporting interim order. There is regarding the recommended.
Subsequent development.
And now, well, only what we have for 1110, 1111.
In the read petition 95, they have not included, they have not impugned the work, they impugned read and work award. I suppose work.
That was for recommendation. They
Recommendation.
have challenged the recommendation in 95.
But award was not challenged. So thereafter, they have filed this
Now,
composite.
we have challenged the approval. WPC 1111 is for approval.
Okay.
Documents are the same. There's a couple.
Some document, my
Same
Okay.
Documents are the same.
Okay. 111 is challenging the
approval.
And this
And 195 is challenging the recommendation.
okay. I'll just examine passwords in the chambers.
My Lordship, this is a writ petition challenging the impugned order dated 1903. That's in page number 16. And before that, I would like to request Lordship to page 18, page number 18. From this application only, this everything has been prop up. So page number 18 is the application being filed by my mother, who is no more. So she has been working as a regular employee in the State Pollution Control Board. And based on that, the application has been placed before the Director, Department of Housing, Government of Arunachal Pradesh on 12 April 2024. since there was a vacancy in this quarter. So therefore, subsequently, it was examined by the director of the department and it was put up. And later on, verbally by assurance, I had my mother along with me, we shifted to that quarter. And subsequently, as per the record from then onwards, 2024 April onwards, till that's in page number 18. I had been paying the electricity bill of that quarter. So it's there in page number 19. Page number 19, Lordship. So that's the electricity bill in the name of my mother, late mother. And subsequently, there was some flood erosion nearby that quarter. So as per after verbal consent from the department, my mother along with me, we had constructed one protection wall also to protect that quarter. And even as for family gathering, those kacha house has been constructed in 2024 April. Then onwards, I had been in this quarter along with my mother, and quarter has been verbally consented by the concerned department in my mother's name. But now, unfortunately, what happened in the month of February, I had been informed, my mother has been informed that my application pending before the Director, Urban Department for Housing. So subsequently, based on that, this one individual, that's respondent number 4 in this writ petition, has made application before the state officer, Itanagar.
Just a moment. You are referring to your mother. You are not a government servant.
No, Lordship, I'm her son. But now, Lordship, please turn page number 27. On 16th of March, on 16th of this last month, March, my mother passed away due to this respiratory failure. Now, why I came before this honorable court is that there is a arbitrary one order notice being issued by that officer based on this individual means private respondent being complained to that authority that I should be vacate that quarter within 5 days. And my mother was died on 16. And order was passed on 19 after knowing that my mother is no more. Now, today is 1st of April. I came to know on 25th of this month. Now, within 5 days, how I can shift from that? I need a time. Just give me time so that I can move out from that quarter also. And apart from that, I had been...
If you are not a government servant, you must be thrown out. You will not be given time to go out. You will be thrown out.
Lordship, that I agree. I'm not against that.
No.
But my mother is a government servant who has been occupant of that quarter.
Let him apply and get it. It will be the authorities who will give it. You can't overstay it.
Lordship, but I may be given because within 5 days, because there is a rituals in...
5 days is over. You see, I am occupying a government quarter. As I am holding up this post, I am occupying a government quarter. Now, supposing I die, and in my custom, for 5 years they can't shift. What happens to this quarter? My family members will continue to stay there for 5 years. If I can demonstrate that in my community, 5 years after the death, they can't shift, then what happens?
No, Lordship, I'm not into that. I'm not saying that 5 days. I'm saying that only 5 days from this 17 March.
16th.
Now I need at least few days. I'm not saying that I will occupy that quarter. I need time to shift all my mother's, all my family materials from that quarter.
Do it.
So meanwhile, I may be just Because within 5 days, how Lordship, it's not.
5 days is already over.
So that also Lordship without.
If it was 19.
Yes.
From 19 to today's 1st, how many days? It's more than 5 days.
I received this not in my name also. The order was passed against my auntie name who has been asked to take care of that quarter. Meanwhile, because that funeral was going on. So, and apart from that, Lordship, even this, I don't know why this department has allotted 2%.
That is for the department to see.
Now,
it is their problem.
now I need only a few days if proper date has been given so that I may be given opportunity to
an enforcer, we can't.
Otherwise, Lordship, how suddenly, because since my father is also not there, I am an orphan, and she was the only person who was working as a government employee, my mother. Now I have been suddenly asked to move out that quarter. I need a time to get alternative accommodation, Lordship.
My difficulty. Few days back, I was ill. I went to a government doctor. He asked me to come to Guwahati Medical College, and they inspected my body. And ultimately, the doctor said that, sir, we are sorry to inform you that you don't have a heart. They did not find my heart there. I'm a heartless person. Can't help it.
But now, Lordship, I'm helpless. I need few days, at least 10 or 15 days, give me so that I can get alternative accommodation.
Not even a day. We can't permit that. I'm sorry, I'm dismissing the question. Mr. N. Chameng, Leonard, you are Mr. N. Chameng, correct?
Yes, yes.
Leonard counsel for the petitioner. Also heard. Yes, I think you are supporting him.
No, Lordship.
No.
Because, Lordship, first of all, petitioner doesn't have any locus. Even his mother was not an LOT. He was staying there illegally.
Lordship, for last 1 year, that application is pending before in director.
And then his application, Lordship, there is a proper application form. It's not in proper application form also. This is a simple application form, but then, Lordship, the application has been submitted only in
There's something wrong in your government.
12th April 2024.
There's something wrong in your government.
Lordship.
Who is the owner of the that quarter?
Lordship, here, Lordship, in between how they have come here,
no, that's okay.
People forcefully enter.
But who is the owner of the of that house?
Lordship, without this one, I cannot say instruction. But then, Lordship, this has been since already, Lordship, employed.
But you see,
owner is now this Lordship 43. Lordship, page 24.
Yes.
He's the LOT, Lordship. He's the LOT.
So the authority is director.
Yes, Lord.
Authority is director housing, Lordship. It's already allotted, Lordship. 14 November 2024, Lordship.
But
Lordship, it's on record. My application is pending before the director only. It's there in page number 18.
Respondent numbers 1, 2, and 3.
When government employee is not there anymore.
By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the notice number, so page 16, dated 19/3/2025, issued by the circle officer come estate officer, Itanagar Capital Complex, by which on complaint made by respondent number 4, the one Srimati Biri, B-I-R-I, MEMA, M-E-M-A, within bracket, Byabang, B-Y-A-B-A-N-G, bracket close, Itanagar, was directed to vacate the government quarter mentioned in the said notice, within 5 days, failing which appropriate action was threatened. Next one. The case of the petitioner is that his mother, within brackets since deceased, bracket namely, Srimati Takio, T-A-K-I-O, Yano, Y-A-N-O, was, when alive, was working as a peon in the establishment of the Arunachal Pradesh State Control Board. And she was allowed to occupy quarter number 43, type 2, Roman 2, located at D dash extension, D capital D dash extension at D sector The D sector is where is Itanagar or Naharlagun?
Itanagar.
Itanagar. The learned counsel for the petitioner has submitted that the petitioner has constructed a boundary wall and has also constructed a room in the premises It is also submitted that on what is the date when your mother expired?
16 March 2025.
The mother of the petitioner has expired. However, on a complaint made by the respondent number 4, the impure notice was issued on 19/3/2025 and served on the petitioner on which date was it served?
25.
On 25/3/2025. Next paragraph. The learned counsel for the petitioner has submitted that the notice dated 19/3/2025 is arbitrary and illegal. It is also submitted that the person in whose name the notice was issued is not the occupier of the said premises, but it was his mother who when alive was holding the premises, and as the petitioner is in bereavement, Srimati Biri Mema, within bracket Bayaban, maternal aunt of the petitioner, was looking after the premises. It is further submitted that according to the customary rights of the community of the petitioner, the petitioner cannot be asked to vacate the said premises during the period of his bereavement. So accordingly, it is submitted that the petitioner is seeking about 2 weeks' time to make alternative arrangement. You said 2 weeks, right?
Yes.
How much time you said?
Yes, Lordship.
How much time you said you wanted?
At least 2 weeks, so that I may get alternative, because it's very difficult to get suddenly is to see, and
it is also submitted.
Or till returnable date also.
In the meanwhile, the petitioner has the when her mother was alive, she had submitted a representation dated 6/2/2025 for allotment of the contract to her, which has not been disposed of. Next one. Next, I continue. The learned counsel for the petitioner has also referred to the documents annexed to this rate petition, and it is submitted that the same quarter has been allotted to 2 persons by separate orders dated 25/9/2024 and 14/11/2024. Next.
Sorry for interference, but this is not to the 2 persons. Other one is quarter number 44 and other is 43. Not the same quarter.
Okay, we'll record it, but he said that it was 2 persons.
Yes, I did. But then if your lordship see 23
we'll
is
record your statement.
44. Yes.
We'll record your statement. Next one. The learned additional senior government advocate has opposed the prayer made in this rate petition. So it is submitted that that if the 2 allotment orders dated 25/9/2024 and 14/11/2024 are is perused, it will reveal that the order dated 25/9/2024 was for allotment of residential quarter number 44 within bracket T-Roman 2, and that the allotment order dated 14/11/2024 was in respect of government quarter number 43 public T-2.
Yes.
It is also submitted that as the petitioner is not a government servant, he has no right to occupy any government property. Next paragraph. On an examination of the materials available on record, it is not the case of the petitioner that he is a government employee and has any right to occupy any government quarter. The mother of the petitioner is stated to have expired on 16/3.
Yes.
2025. And therefore, the petitioner would have no right to overstay in quarter number 43 within bracket, oblique type 2 at D sector, Itanagar. They claim that the due to the last rites and the bereavement period, arising out of the death of his mother, would also not entitle the petitioner to retain a government quarter accordingly. Overstay of the petitioner in the government quarter cannot be given an imprimatur of the court. So therefore, the court does not find any merit in the writ petition and to justify the holding over of the government quarter bearing quarter number 43 of the type 2 at D sector, Itanagar, or on any ground whatsoever. Accordingly, the court is disinclined to admit this writ petition, and accordingly, this writ petition stands dismissed on the motion stage without issuance of notice on the respondent.
Right. Highly obliged, Lordship.
Item number 7.
Yes, I got the information. The contract is already executed.
Lordship?
The contract is already executed.
No, Lordship, I think.
25.
Lordship, I think it's not started, Lordship, I think.
Pardon me?
Work not started, Lordship.
May not be, but since
Lordship, it's matter of only 1 week, Lordship.
No.
Lordship, because if tomorrow I become successful, Lordship, I'm ready to, if there is a change in cost also, I'm ready to bear, Lordship. Now, since work only, they have served the notice, but work is not started, Lordship. It's a matter of, Lordship, only 1 week. Lordship, this construction work is not the work of something that perishable items also, Lordship.
No, that's okay, Mr. Bori, but since they already entered into a contract And they've interpreted this.
Lordship will fix on Monday, Lordship. Then it's matter of only 3 or 4 days, Lordship.
No, because then it's regarding the construction of a hostel building.
Lordship, tomorrow if the farm becomes illegal, then Lordship, what will happen? An illegal farm doing a work, there may be case, Lordship. That's why, Lordship. It's matter of only 4 or 5 days, Lordship. There is any change in course, I'm ready to bear, Lordship. If I'm not successful, Lordship.
And Mr. Tarak, this ground which they have taken, that this that their engineer is a government servant. If that be so, then you'll have to make an inquiry. Page 2, he said he's a government servant. Then his tender would be defective. Respondent 6, it's a specific statement made in the writ petition. That the respondent 6 gave this person's certificate. There's a specific pleading that he is a government servant.
That part, we have to check it.
Lordship, and Annexure 9 also, work completion, it is of District Changlang, which is around 300 far away from Lower Sing district, Lordship. This is also prima facie, Lordship. It's their documents, Lordship. Annexure 9 and 10.
Where do you say he's working? Mr. Buri, where do you say he is working?
Lordship here.
Paragraph 15 here only stated that he has learned that. He is not stating that where he is working on which department.
We do, Lordship, we only, that's why we are saying that the evaluation was not done properly. They have not cross-examination anything. And
no, you see, in application, no applications, the background of the persons who are who are the nominated staff, the background check is made.
Lordship.
That is only when the contract.
Yes. That's why I have made one representation, Lordship, to Annexure 8, Lordship.
Page.
This is only mere allegation.
Page.
Lordship, page 249. Here, I have clearly stated that this all has to be, their work experience has to be properly scrutinized of all the bidders, not only there, of all the participants. They have not done that.
No, that we don't have doubt that they did not examine it.
Yes,
But more than that, they can't do anything.
Lordship, tomorrow if suppose my allegation against them comes true, then Lordship, all work will become illegal, Lordship. That's why only, Lordship, matter of only 1 week, Lordship.
Mr. Tarak will take it up day after tomorrow. Please come to paragraph 14, page 14. And 15. You see here, they say that the contractor was enlisted only on 18 to 2021. And therefore, his work experience is of 2020.
2020 years.
Yes.
So you produce the record of the bid submitted by respondent number 6. This is from which place?
This NIT is of Lower Siang, and
you can get a scan copy and show it to us. Mr. U. Boril and counsel for the petitioner. Among others, the petitioner has stated that the respondent number 6 was enlisted as a class Roman 3 within bracket B and R and symbol, B and R bracket closed under civil category while order dated 18 to 2021. And accordingly, it is questioned that how the respondent number 6 could have executed a work for a sum of rupees 203.00 lakh prior to his enlistment as a class 3 contractor. Whereas, as per the schedule to the Arunachal Pradesh district-based entrepreneurs and professionals within bracket incentives, development and promotional bracket close act, 2015, class 2 and class 3 contractors are only eligible to participate and execute the works for rupees 2.00 TO2 3.00 crore. So accordingly, in order to examine the said issue, this is the matter on the court is inclined to Mr. G. Tarak Lanet, standing counsel for the RWD,
Yes, RWD.
To produce a scanned copy of the relevant documents of the bidding documents of respondent number 6, specifically relating to his the aforesaid aspect of the matter. Next one, list on P 4/2025 in the motion column. Just before that, you also write, just before the last line, you also write. It may be mentioned that the learned standing counsel for the RWD has produced a copy of communication dated 24/3/2025 to the respondent number 6 to proceed with the work. So I said communication is retained in the record. Day after tomorrow. If you can't print out, you can give a scan copy, we'll see it here.
I know.
Yes.
Lordship, for me. Lordship, in this petition, we are challenging the non-consideration of our bid document. Bids, Lordship. We're challenging the evaluation report dated 22/3/2025. Lordship.
Page?
Lordship, it would be page number 50, Lordship. 50.
15.
50.
50. Yes.
Basically, Lordship, if I may, the last paragraph of the page.
Yes.
Yeah, if I may read.
Physical documents not submitted.
Pardon, Lordship?
Physical documents not submitted.
Physical documents are not submitted.
Yes.
That is the case. They've alleged that we have not submitted our physical documents, but we had submitted our physical documents to respondent number 7, who was the authorized person designated by respondent number 5 to receive the documents, Lordship.
Respondent number 7. Who is respondent number 7?
He is the cashier, Lordship, in the office of the executive engineer, Lordship.
Cashier?
Yes, he was the authorized person by the respondent number 5 to receive the bid documents, Lordship. Accordingly, he has even given a receipt of the EMD.
Where is the document of authorization?
Lordship, that we were verbally informed to submit it before him, Lordship. Lordship, at page number 24, Lordship, even he is the one who has given us the receipt of deposit of EMD. Page number 24, Lordship, the cashier. Respondent number 7, Lordship.
But that can't be come to page 55.
Yes, ma'am.
The tender document contains the place where it is submitted.
Yes, Lordship. Yes, Lordship.
In no establishment, cashier is a person who will be authorized to receive documents for tender.
Lordship, that part, if we may be allowed, we can, because when we went there to submit it, as informed by the office that he was a designated person who was to receive the documents, we had given it, Lordship. So at this moment, Lordship, we don't have the...
Were you present when the bids were opened?
Yes, Lordship.
Where is the document of opening of the bid? Did you raise any objection on that ground there?
Lordship, we submitted a representation immediately on the next working day, on Monday, 24th of March, detailing how everything transpired. Page number 51, Lordship.
Okay, but where is the memo of the tender opening?
Lordship, that we don't have in our position.
It's not there.
Yes, Lordship.
And where is your representation?
Page number 51, Lordship.
51.
Yes, Lordship. If my lord will read para 2, lordship, then we have narrated our grievance, lordship.
As per your this page 51, paragraph 2,
Yes,
the
Lord.
originals were written to you. You did not give he kept the Xerox copies. So you did that at your own risk.
Lordship, the EMD in original was submitted to him and everything as photocopies, lordship, because there is nothing that we have to submit the originals, lordship. We have to give a physical copy, lordship. So we had produced the originals and
But this is not physical. He retained Xerox copies.
yes, Lord, he
According
returned the
to you.
Xerox copies of the above documents,
But this
lordship.
is not physical submission of document.
Lordship, we have given the original physical documents. He had photocopied them and kept the photocopies and returned the originals to us, lordship. So the physical condition of submission of physical documents was fulfilled by us, lordship.
But that could have been done today. Today is the official day.
Pardon, lordship?
Today is the official day.
Today.
April Fool's Day. But this is not in accordance with law. Yes, Mr. Tapin.
Lordship. Lordship, on last occasion, I was asked to bring the lordship, instruction, lordship. And this is the instruction that has come, lordship. If lordship, come to page 50, lordship.
Just a moment. Page 50.
Five zero read petition, lordship.
No, the representation is at page
51, lordship.
51. 24th March. What is the date of opening of the tender documents?
23rd, lordship. 23rd. 22nd March.
22nd. It was
22nd.
22nd.
It was a Saturday, lordship, I believe.
You have a copy, just show it to
Yes, yes. So,
Government Council. You see, your representative was there. Your signature is put that in a hard copy not submitted. He's put his signature.
one representative, lordship. He is the authorized person, lordship.
Hmm?
He is the authorized person who represented the petitioner from lordship. And their lordship is remark is the physical document is not submitted. And he put his signature also, lordship. And the last page is the authorization letter, lordship, by the firm, lordship. On Dr. Ribal, lordship, he represented the petitioner in the at the time of opening of the bid, lordship, documents, lordship. And that is the checklist, lordship. After while opening, lordship, this checklist has been issued. And all the representatives, they have put their signature, lordship.
Mm.
And basing on that, lordship, the page 50 has been issued, the summary of the lordship bid
Page
opening.
50.
Lordship. Page 50 of the read petition, lordship.
Sorry, we can't. If you notice, we'll have to dismiss your petition.
Lordship, the representative had not informed us that he has signed it in that capacity, Lordship.
You can't help it.
Lordship, he's an aged guy, whether he signed it as an attendance or acceptance of that is because he immediately submitted an representation on the
No,
24th.
you see, let us test your submission. If somebody signs this over these signatures, this pro forma cannot be printed. Supposing I take a blank signature and I try to replicate by making a this chart, I'll not be able to do it. This is signature on a at a place, designated place.
Yes, Lordship.
And if Lordship see the Lordship 4-page authorization letter, Lordship. Here, Lordship find 2 persons have been shown to have been authorized, but tick mark has been put in the second person, Lordship, Dagger Riba, Lordship. And at page 3, Lordship, the previous page, Lordship, Dagger Riba, Lordship, he represented the firm, Lordship. And so far the representation is concerned, Lordship, that has been filed by that past one, Lordship, the another one, Lordship.
Okay. Doi
Riba. But in authorization, tick mark has been put in the name of the Lordship, Dr. Riba, Lordship. Otherwise, both of them, Lordship, they are authorized persons as per this authorization. Okay. And this fact has been suppressed in the present writ petition.
It's okay. He is not instructed. Don't go it so seriously.
But the act of the authorized person is the act of the firm, Lordship. Legally, Lordship. Technically.
Mr.
G. Talo, Lordship.
G. Talo.
G. Talo, Lordship.
G. Talo, learned counsel for the petitioner. Also heard Mr. S. Thapil, a senior government advocate, appearing for the respondent numbers 1 to 6. Next one. This is the document appearing in the first prayer, 24/3/25. Where is that?
Pardon, Lordship, the bid summary.
Page number 13, 12 and 13. Your first prayer is to challenge bid evaluation report dated 24/3.
Yes.
Where is that document?
Lordship, pardon, this should have been 22/3, Lordship.
Huh?
It should have been 22nd of March.
5050.
50.
The technical bid summary, Lordship. This this has been addressed as
no, your prayer is 24/3.
My lord, I believe there is a typographical mistake regarding the date of the representation has been.
It should
reflected.
be 22/3.
22/3.
Oh, okay. Filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the bid evaluation report dated 24/3/2025. Within bracket, you write SIC, full stop. Should be 22/3/2025. Issued by the executive engineer, PWD, Basara Division. By which the names of 4 bidders, excluding the petitioner, were recommended for technical security and evaluation. The petitioner has also prayed for a direction upon the respondent authorities for re-evaluation of the technical bids submitted for the tender in question and for quashing of the process, tender process of the NIT dated 13/3/2025. Next one. In brief, the case of the petitioner is that pursuant to a notice inviting bid dated 3/3/2025 for the work of, this will be page 18. Pencil mark. This one. For an estimated cost of rupees 20, 75, 75, 000. Also type in words 25 crore, 20 crore, 75 lakh, and so, the petitioner and 6 others had participated. Although the bids were uploaded successfully, the bid submitted by the petitioner was rejected on the ground that the petitioner did not submit physical bid documents as required under clause 2.11.2 to the designated address mentioned in clause 2.11.4. Next one. The learned counsel for the petitioner has submitted that on (18/3/2025), the petitioner's representative, namely DOI RIBA, had gone to the office of the executive engineer, PWD, Basar division, along with original bid documents in a sealed envelope. And the same was handed over to one Sri Jumi, Jumi, Basar, cashier in the office of the executive engineer. Within bracket, respondent number 7, who took out all the documents, photocopied it, and after retaining the photocopied copies of the documents, returned the original documents with instructions to bring it on the bid opening day, i.e. 22/3/2025. Full stop. The learned counsel for the petitioner has submitted that the cashier in the establishment of the executive engineer was the person in charge of receiving the documents. So accordingly, it is alleged that the office of the executive engineer, PWD, Basar division had manipulated the petitioner, the petitioner's firm by tampering with the sealed, tampering with the envelope containing, tampering with the sealed envelope containing the original documents in a biased manner. First of, accordingly, the learned counsel for the petitioner submitted that the petition be admitted for hearing and the entire matter be examined. Thereafter, the reliefs, as prayed for, be granted. Next paragraph. Per contra, the learned senior government advocate has referred to the order dated 28/3/2025, and it is submitted that that he had sought for some time to obtain instructions, and accordingly he has produced instructions in form of covering letter dated 22/3/2025 by the executive engineer, Basar division, PWD, addressed to the superintending engineer, Basar circle, a checklist for opening of tender signed on 22/3/2025 by the representatives of all the bidders, as well as a copy of the letter of authorization dated 22/3/2025 issued by the petitioner to the executive engineer, Basar division, thereby authorizing two persons, namely, number one, Sri Doi DOI Riba, and within bracket number two, Sri Dake DAKGE Riba. First off, accordingly, committee submitted that in the checklist, which was signed by the authorized representatives of the bidders on 22/3/2025, the representative of the petitioner who had attended the bid opening was not Sri Doi Riba, but he was Dagge DAKGE Dagge Riba, who was signed at the designated place alongside the note regarding the petitioner, give a dash, then inverted commas, hard copy not submitted, inverted comma closed. First off. It is submitted that on the date when the bid documents were examined, i.e. on 22/3/2025, Sri Dagge Riba was the authorized representative who was present and against whom who is the author, who is one of the authorized person of the petitioner. However, in this petition, which is in which the affidavit in support of the writ petition is sworn by Sri Doi Riba DY, he has projected in the representation as if he was the person who had gone to submit the documents. Next step. Next one, on the direction of the court, a copy of the instructions, the four-page instructions produced by the learned senior government advocate. You give it to him, a copy. It has been handed over. Huh?
I'm giving it.
You give it to him. Huh? Has been handed over to the Learned Counsel for the petitioner. Next paragraph. The checklist for opening of tender clearly, it is clearly mentioned that hard copy of the bid documents were not submitted, which is countersigned by Sri Dagge DAKGE, Dagge Riba, one of the two authorized persons of the petitioner. Full stop. It appears that on the day when the tenders were examined, the representative of the petitioner did not raise an objection that documents were handed over to the respondent number 7. Moreover, when the relevant tender clause number 2.11.2 requires that the physical documents were to be submitted at the designated address mentioned in clause 2.11.4. The providing of documents to the respondent number 7 was clearly at the risk of the petitioner. So there is no acknowledgement by the respondent number 7 about receipt of documents. Therefore, the condition of the tender found to have not been complied with by the petitioner. The representation made by Sri Doi Riba, DUI Riba, on behalf of the petitioner it appears to contain incorrect statement that he had submitted the documents to the respondent number 7 because the other representative of the petitioner, namely Dukge Riba, DUKGE Riba, was present on 22/3/2025 when he had signed the checklist for opening of tender, where he has signed against the remark that hard copy was not submitted. So therefore, court does not find any merit in the reputation, and accordingly, the same is dismissed. The motion stayed without issuing of notice on the respondents. There shall be no others to cast.
Much obliged.
Just instructions produced are made part of the report.
Malad,
Yes.
Malad, before I come to the merit of this case, let me have prayed that item number 27.
Principal seat, I think.
Malad?
You should go to the principal seat.
No, Malad. Malad,
Yes.
this has been clarified in the item number 27 because this is not pertaining to payment of compensation. That case which was sent to principal seat was payment of compensation. Here, Malad, as in item number 27, this is for the acquisition of the land. There was no acquisition. Malad, item number 27 also may be taken. Malad, your lordship has clarified this, the matter. So this is of the same nature. No direct payment, no direct prayer for payment of the excess compensation. Acquisition.
Mr. Hiran, please examine this order. Should I issue the same order? Take this order. You have a copy of the order?
No, my lord.
Just write to him.
My lord, in fact, here.
No, I don't know. Because of that note, I did not examine it.
Yes. In that earlier case, there was assessment was made, but no acquisition. So your lordship held that without acquisition, how can you make this assessment?
So since I did not check it out.
And in this case, it is totally a different area of the same project, but totally different area, 365 and 451.
No, I don't know. Because of the note, I did not even examine it. Let him check it out.
Otherwise, we can take it up on day after tomorrow.
Just let him check it out.
Your lordship, Mr. N. Rathan would be the appropriate.
Okay.
Yes, because he was appearing this case.
List it day after tomorrow then?
Yes, tomorrow. Yes, day after tomorrow, your lordship.
Okay.
Along with these two cases together.
In item 9.
No, only to your lordship may kindly observe that whether this case, present case, will be covered by this order of the Registrar General of 1 April, and with it is with the same order can be same order as in passed in 44 can be passed.
Counsel for the petitioner has submitted that the present date petitioner is not relating to claim of compensation for the projected affected people for the construction of Lower Subansiri hydropower project as the land of the petitioner was never acquired. Correct?
Land has not been acquired.
So it is submitted that
in fact, no assessment also was made here.
A similar matter which is for a different region, different area.
Yes.
Is also listed today, being WPC 44 AP of 2025. So accordingly, it is submitted that this matter is not required to be sent to the principal seat in terms of communications dated 1/4/2023 issued by the Joint Registrar within bracket Judicial of the principal seat of this court. Next one. Mr. Y.D. Ram, the Government Advocate, submits that Mr. N. Ratan, the Additional Advocate General, would be appearing in the matter.
Yes, Lordship.
And accordingly, please that the matter be taken up on 3/4/2025. Just list on 3/4/2025.
Obliged, Lordship.
Obliged, Lordship.
In the other matter, this is item 27.
27.
Just say both sides are represented. List this matter on 3/4/2025. Okay.
May I please, Lordship?
Yes.
Lordship, this is a writ petition for challenging the legality and procedure fairness of the tender notice dated so and so. Indicated.
This I cannot go through it. You are not given a synopsis here. Better give a synopsis.
Synopsis also not there. Synopsis is there.
In my copy, it is not there.
Otherwise,
check up.
My lord, what is the grievance of the petitioner?
We don't know, but
That
I did
also
not go through it. Let him give it. We'll take it up tomorrow. There. No, just see whether it is synopsis is there. It's not there, no? When you will file it?
Tomorrow, by tomorrow.
By tomorrow you file it. Okay.
Yes.
We take it up on Friday then.
Okay, Lordship.
As the there's no synopsis attached to this petition. The learned counsel for the petitioner undertakes to submit the same next para according. The registry command receipt of the synopsis shall tag it with the record list on 4/4/2025. But he is no, it's okay. Please wait. Oh, this is about just record the presence of Mr. G. Tarak, standing counsel for his present. Yes, item 11.
My lord, in this case, my lord, I'm aggrieved by the two impugn order dated 28th January 2025, my lord. Passed by learned Deputy Commissioner. The two orders same day as order has been passed by. My lord, brief fact, my lord, leading to the passing of this order, my lord, is that sometime year 2011, my lord, there was a complaint made by the private respondent number 6, my lord, alleging that there's encroachment over the allotted land of the private respondent, my lord. Pursuant to that complaint, my lord, series of ground verification was carried out, my lord. In all the, my lord, altogether, my lord, 4 ground verification, my lord. I've annexed the ground verification at annexure 239, my lord, wherein it was found that rather the private respondent was found to be in excess occupation of from actual allotted area. They were found to be in excess occupation of 65,000 square meter, my lord. And having found, my lord, despite of this, my lord,
in this writ petition, you have compartmentalized the pleadings into two parts. Number one, you are challenging the order of eviction on merit.
My lord.
And you are also saying that the earlier adjudication,
yes, ma'am,
was set aside, which you say that this is untenable.
Yes.
Correct.
My lord.
Now, which part are you giving more focus?
My lord.
The stress is in which two parts of the order?
My lord, the first part, my lord, the first order, my lord, this, my lord, earlier, my lord, the being agreed by the decision of the earlier DC, my lord, Deputy Commissioner, the petitioner approached this honorable court, my lord, by way of civil revision petition, my lord, under Section 50 of Assam Frontier Administration Justice Regulation, my lord, in which point of time, my lord, the Deputy Commissioner was empowered to adjudicate a civil dispute, my lord. They had been given power to trial the civil dispute, my lord. Since the order was passed by Deputy Commissioner, it was a revisable order. Therefore, revision was filed before this honorable court. And having found that order was not in accordance with the Deputy Commissioner, learned Deputy Commissioner order passed was set aside, my lord. And it was directed to remand and remanded back to pass and consider the matter in accordance with my law, in accordance with law. But despite of that order, my lord, matter remained pending, my lord. There was a ground verification, my lord. That dispute part, my lord, that has been cleared in series of ground verification, that the private respondent is, the petitioner has not rather encroached the allotted area of the private respondent 6. Rather, private respondent is found to be in excess possession of the more than 65,000 square meter, my lord. That was the consistent finding of the verification report but done by the authority. And despite of this order, my lord, despite of that verification, nothing has been done. In the meantime, my lord, 2021, till 2021, nothing has been done. And in 2021, my lord, the government of Arunachal Pradesh, they have legislated passed the enactment, my lord, called Arunachal Pradesh Civil Code Act 2021. Whereby, my lord, the power of the Deputy Commissioner to adjudicate a civil matter has been abolished, my lord. Now, having considered this aspect of matter, the Deputy Commissioner transferred the matter to the state officer, my lord, EAC come state officer, my lord, to adjudicate a matter and dispose of the matter, because state officer was empowered are the competent authority under, in case of encroachment, public premises, he's the competent authority to pass any order, my lord. So, Deputy Commissioner, after having transferred the matter, my lord, the state officer has conducted trial, and after examining, having heard, my lord, this order, my lord, order that at Annexure 16, my lord, this order was passed, my lord. Page 99, my lord. Page 99, this order was passed. And this order, my lord, page 99 order, my lord, order that the 20 September 2024, passed by state officer, my lord, was challenged by the private respondent 6 by way of appeal, and this is appealable, my lord, under Section 12 of the Public Premises Act, my lord. While considering, my lord, appeal filed by the private respondent number, my lord, at Annexure 18, my lord, learned Deputy Commissioner, my lord, page 120, my lord, 231, passed the impugn order, holding that state officer do not have a jurisdiction to pass such order, my lord. Whereas in the under statute, my lord, state officer is the competent authority to pass the order, my lord. That has been passed, holding that state officer has no jurisdiction, my lord. And
On the same day, my lord, on same day after having passed in the appeal filed by the respondent number 6, my lord, on the same day, on same date, my lord, again another impugn order at Annexure 19, my lord, 132 was passed by the Deputy Commissioner, assuming the original jurisdiction of the state officer, which he cannot do, my lord, which he has no jurisdiction, my lord. Because this is...
We'll tell you.
My lord.
Come to page 123.
My lord.
Paragraph 9.
My lord. My lord, that is why, my lord.
Correct. Then come to page 127.
My lord.
See, same thing again in paragraph 4.
My lord. My lord.
It gives a reference to CRP 7 of 2017.
My lord, my lord.
Now, please again come to page 129.
Yes, my lord.
Paragraph D, last part.
My lord.
Again, writ petition 268.
My lord.
So it was remanded to the Deputy Commissioner.
My lord.
Then please now come to 130.
My lord, that was there.
Third paragraph again, High Court.
My lord.
Then come to 131.
My lord.
The first paragraph, again the High Court order.
My lord. My lord,
now you see, nobody moved the High Court for modification of the order so that the jurisdictional authority can hear it.
My lord.
When there is an order of remand, the jurisdiction on the said authority is already vested.
My lord, my lord. Now, so far, my lord, remand, my lord, it was to pass in accordance with the law, my lord. Accordance with my lord in law. Only.
It's not only that. When the High Court remands a matter to a particular authority, the other authority cannot take it up.
My lord.
So the order by the state officer was palpably not in accordance with the directions issued by this court.
My lord.
A delegate will not have a power to further delegate.
My lord, and that apart, my lord, this transfer order dated 11 April 2020, my lord, page number 98, my lord. This order should have been, my lord, recalled, my lord. This order has not been recalled, my lord. Based on this, my lord, transfer order, my lord, this Annexure 16, my lord, order was passed by the state officer, my lord.
That would be
98.
That would be wrong.
My lord, that's why, my lord, this order should have been recalled, my lord. This order has not been recalled. When on one hand...
Who will recall it?
My lord, this is the Deputy Commissioner, my lord.
No, Deputy Commissioner cannot recall.
My lord, this has been transferred to the state officer, my lord.
You see, that's why that court would have no jurisdiction.
My lord.
If the High Court is remanding a matter, then in the course of hearing, you should have moved this court to have this order altered.
My lord, even in that part also, my lord, assuming that the jurisdiction part is all right, my lord. That part also, my lord, without entering into the jurisdiction part also, my lord. Now on the merit also, my lord, my responsible submission. When, my lord, they're consistently finding, they have found that the application for allotment, my lord, is pending since 2015, my lord. Now that aspect, my lord, without entering into without touching the jurisdictional issue, my lord, I'm coming to the merit part also. Now they have admitted, my lord.
Where is the, under which law the allotment applications are made?
My lord, it is under Land Settlement Act, my lord, rules, my lord.
Under Land Settlement Rules?
My lord. It can be.
Which volume will I get it? Land Settlement Rules, that Act.
My lord, it is in rules, my lord, rules.
Which is the clause?
My lord, Arunachal Pradesh Land Settlement Records Act 2000. My lord, rules is not here, my lord. The procedure part is dealt with by the rules, my lord. It's a volume 7, my lord.
No, we have the rules.
My lord, rules. My lord, rule part, my lord, I could not, my lord. My lord.
What is this? This is Act.
Yes, my lord.
Yes. We have this volume 7. You have a copy. Listen, this is our book. Okay.
My lord. In similar situated case, my lord, in identical matter, my lord, coordinate bench of this honorable court, my lord, has passed a judgment, my lord, wherein it has been observed, my lord, when the application for allotment is pending, my lord, parallel proceeding of the eviction, my lord. This would not be, my lord.
We are interested to know because of the fact that somewhere I have read in this petition that the land allotment is more than 1 lakh square feet.
My lord.
Square feet or square meters?
Lordship, 30,000.
My lord, this is my lord,
94 square meters.
this is my lord, amalgamated, my lord. That is the petitioner is 13 numbers.
Maybe.
Last time when I read this act, I think that much of land cannot be allotted.
My lord, 30.
There's some 500 or 1,000 meters or something. I do not find anywhere that 1 lakh square meters of land could be allotted. That's why I'm just trying to find out.
My lord, in our case, my lord, the petitioner is 13. 30 is in number, my lord.
Maybe,
Jointly.
but then more than 30,000.
30 is, since I don't remember, what is the land which can be allotted? 30 persons, 1 lakh.
My lord,
My lord, 30,000. My lord, then that one, my para 11 and 12, my lord, this, my lord. Para 11 and 12.
Lordship, since this is government and area right, they cannot demand the lordship allotment, lordship.
That is why government would consider, should consider. No, but if it is, if I remember correctly, under the Land Act and rules, power of eviction is not there. Power of resumption of the land is there. My lord. My lord, again, another, my lord, decision, my lord. But what is the law? Is it eviction or it is resumption? If the land is not utilized or not used in accordance with the allotment,
yes,
the government has power to resume land. My lord,
Yes,
but in my case, my lord, the application for allotment is pending since 2011, my lord. 15, my lord. Now things, my lord, that is the government, my lord, take a final call, my lord, whether to reject, well, to allow or not, my lord. My lord, here also, my lord, the para 12, 13, and 15, my lord, 21, my lord. It's relating to, my lord, when Deputy Commissioner, my lord, being the appellate authority under public premises, my lord, he cannot assume the power of the state officer and issue direction, my lord. No. My lord. No, if it is under this act, I don't think this should be applicable. My lord, now the decision would not be applicable. My lord, in that part, my lord, my respectful submission, my lord, the government, my lord, the government is the ultimate authority to consider, my lord. Land department, my lord. I just forgot, I don't remember. Which is the provision in the act for land allotment?
lordship, which one? Lordship? Which one, lordship?
No, if it is this Land Management Act.
Oh, no, lordship.
My lord, allotment part is, my lord, it's under rules, in the rules, my lord. No, but Act must say so. Then only rules will come. Rule cannot be divorced of the Act, my lord.
Yes.
My lord, so far, the area, my lord, to the what extent that allotment can be, it is not provided under Act, my lord. Yes, yes, it's there in the rules. My lord, rules there, my lord. In the rules, my lord, it's there. No, you see, the Act will give a broad parameter and the rules will have the details. My lord. So therefore, in this case, the power to allot land, immediately thereafter there is an order of resumption. My lord, section 12, my lord. Of the Act, my lord. But there also, my lord, the area, my lord, that is not mentioned, my lord. It is there in the rules. I distinctly remember it. But my lord, it said that it should not be exceed 5 acres, my lord. No. I may be wrong by some meters. But not
There
that,
cannot be individual allotment, lordship. There cannot be.
I can't be that wrong. Allotment of government land, my lord, for agriculture and housing purpose.
For agricultural institution, lordship, that is different thing, lordship. This is to individuals, lordship. It is not more than 500 square meter, lordship.
My lord, even private respondent, my lord, they have been allotted more than lakhs, my lord. Ah, yes.
It's a institution.
124 of the rules. And yes, 18 years of the government and maximum 500 square meter for commercial, maximum 1,000 square meter for residential.
My lord, in our case, the total they have verified, my lord, our claim area is 30,000. Now the petitioner is 30, my lord. It's false, my lord. 1,000 each, my lord. The petitioner is 10, my lord. 30, my lord. 30 in numbers. And our claim area is 30,000, my lord.
It's 133.8. Allotment shall be liable to be cancelled. And then re-entry.
Ultimately, that on our application for allotment, but no decision has been made, my lord.
Where is the original application for your allotment of land?
My lord, it is in, my lord, their order, my lord, it is reflected, my lord. My lord, see it. Page 105, my lord. Para 4, para 40, my lord. Application for land allotment by petitioner pending since 2015 and may also be reconsidered subject to the feasibility under laid down rules and guidelines.
Where is that part of the order where you were asked to evict?
My lord will see
page.
My lord at page
138.
138, my lord.
138.
Lordship,
What material do you have? If you are referring to the order at page 138, what materials do you have to show that the land from which you are sought to be evicted is not an excess holding with you?
My lord.
You see, we'll tell you only, there's a judgment of the Supreme Court.
My lord.
On the case of Central Council for Agricultural Research versus Bikartan Das.
My lord.
There, the Supreme Court has defined the parameters of 226 when it is exercising jurisdiction of certiorari. And therefore, we won't examine the decision itself. We are not the appellate authority. Only the decision-making process. So if you can show that the land you are holding is not excess of the allotted land, then we won't interfere.
My lord, the order, my lord, will say, my lord, see at page 105, my lord. 105, 37, 5, my lord, Roman 5, my lord. Deem the claim of petition over the disputed plot is as much valid as that of the respondent, my lord. My lord claim. And my lord, my total area, my lord, see at page 91 as well, my lord. Page 91, my lord. That's verification, demarcation report, my lord. The verification report, my lord.
No, verification report will not do. Because you have been allotted land. Where is that land? Where is the allotment order?
My lord, my lord, Roman 5, page 105 of para 37,
in page 91, at paragraph 3, there is an excess of 65,733 square meter land. And area claimed by you is 30,794. So therefore, this is a finding that it is excess land in occupation.
Madam, that is in respect of private respondent, respondent number 5, madam, 6, private respondent, madam.
Private.
They were holding the excess, madam, excess of actual allotted area, madam.
They have the allotted land now.
They have been in occupation, madam, excess allotted, madam. That's why, madam. That's why the impugn order, madam. This impugn order eviction has been also been passed against the private respondent, madam. Our respectful submission, when our application is pending, madam, at least that should be considered, because so far private respondent number is concerned, madam. He has already been allotted more than lakhs of a square meter. And apart from, on top of that, they are in occupation of they are in excess possession, madam.
You see, your application is for allotment. Can you justify occupation without allotment? Let the eviction be carried out. You will give the direction that if your allotment application is kept pending, ask the authorities to examine it and pass necessary orders.
My lord, that is why, my lord, without
it should be interfere with the eviction process.
My lord, without considering, my lord, this aspect, my lord, this the eviction order is carried. It will otherwise, my lord,
that means you are asking for a perfection of your illegal occupation.
My lord, to see recently, my lord, the Honorable Supreme Court 3-judge bench, my lord, while dealing with the eviction matter, my lord, it should be strictly in accordance with the eviction provision, my lord. Any infraction would be against the rule of law, my lord. Para 29, my lord, I highlight, my lord. There are municipal laws and town planning legislation which contain adequate provision for dealing with the illegal encroachment. Where such legislation exists, the safeguard which are provided, it must be observed. We propose to lay down certain minimum threshold of the procedure safeguard which must be fulfilled before taking action against property of the citizen. The state must follow due process of law before taking action.
This judgment doesn't help you.
My
the reason is in this Thibarwal Akash.
My lord.
The facts was that this man was the owner of a land.
My lord.
And in the meanwhile, the government issued a notification for widening of the road.
My lord,
National highway.
But that is without following due process of law, man. That's why, man.
Not that. You see, that is another aspect. Because of the fact that when the Deputy Commissioner ordered eviction, then this was not followed. But this has got nothing to do with an illegal occupation of land which is not allotted to you.
My lord, in my respectful submission, my lord, since we have been.
This judgment is not an authority on the point that even if you are illegally occupying it and made an application,
my
if
lord,
the application is decided, you will not be evicted. This is not the law here.
My lord, even in that case, my lord, my respectful submission, my lord, at least, my lord, when my application is pending, my lord, and we have been staying since decades together, my lord. At least as a welfare government, my lord, authority, my lord, they ought to have considered our application, my lord. If the government say that we cannot allow, my lord, that is all right, my lord. We can understand, my lord. But that is, my lord, without considering our the prayer, my lord, straight away directing us to evict, my lord. That is, my lord, we are agreed by, my lord.
Come to page 137, paragraph 7, the authority has considered your prayer. 137, para 7.
But spending, my lord, that is admitted part, my lord.
Correct.
My lord, that's why my respectful submission, my lord. At least, my lord.
At page 138, that has been answered in the same para 9.
My lord, that part, my lord. That is why, my lord, I've relied, my lord, 2019, the decision, my lord. BJ Jara, my lord, case, wherein application, my lord, when allotment application is pending, my lord. First, this should have been considered, and parallelly proceeding for eviction, my lord, would
Which judgment? 2019?
My lord, 2019 4 GLT, my lord, just as for BJ Jara, my lord, para 11 and 12, my lord. Here also, my lord, the petitioner was in excess occupation, para 11, my lord. I'll read para 11, my lord. As indicated above, pursuant to the interim order passed by this court, the petitioner continues to be in possession of the excess 15 square meter of the land over which there was construction. The point for determination which would arise in this case is that when the application for allotment of particular land is pending consideration, whether parallel proceeding for eviction the petitioner from same plot of land is justifiable, it appears that pursuant to the application for the petitioner for allotment of 115 square meter, the authorities had taken certain conscious measure in the process of consideration of the said application. Not only physical verification was done and reports submitted, but the sketch map of the entire area was also prepared and same was pending consideration. Without taking final decision on the prayer of the petitioner for allotment, this court is of the opinion that it is not to be held either to be reasonable or justifiable to issue notice for eviction followed by the actual order to vacate. This court in agreement with the submission made on behalf of the petitioner that if the impugn order comes into operation, the process of consideration of her prayer for allotment would not only be infructuous, but the petitioner will suffer legal prejudice inasmuch as the land in question has been stated to be under the occupation of for the last more than 11 years. Therefore, without taking final decision on the prayer of the allotment, the impugn action cannot be held to be justified. Accordingly, same is interfere with. Consequently, the above decision matter. My case is also matter here, matter. My case is more than 20 years, man. We are in possession of the land, man. It's Mother, if we are evicted, my lord, will be rendered homeless, my lord.
You know the difficulty. If we go by section 12,
my lord,
then it is the deputy commissioner who has the authority to allot land.
My lord, that is, my lord, he's the issuing authority, my lord. Actual approval allotment. He's the issuing authority.
We don't know that. But in your case,
my lord,
come to page 134. Paragraph 5, you say that you have filed a representation before the estate officer. He is not a person authorized to accept the application and keep it pending. It's not the deputy commissioner who has kept your allotment application pending.
My lord, we filed the application before the deputy commissioner, my lord. That as order reflects.
This order says it's your case that it is kept pending since 2015.
My lord.
In page 134, paragraph 5, the deputy commissioner writes an order that the representation, when the matter was pending for eviction, the opposite party petitioner in this instant case filed a representation dated 36 before the estate officer.
My lord,
there is nothing on record to show that this is incorrect.
Lordship, in page 132 also in the same order, para 4, Lordship. It can be seen that the area is measuring an area of 1,50,000. 1,50,000 square meter across this. Lordship. In para 4 is recorded.
My lord, in my respect to submission, my lord, this even, my lord, the proportion, my lord, that 1,000, my lord, per head, my lord, per individual, my lord. Now that is the 30,000, my lord, is under our possession, my lord. The jointly, my lord, is in accumulation. My lord, each individual, it's come to, my lord, the 1,000 only, my lord. That's it. And apart from that, also there's also excess land, my lord. My lord, page 91, my lord, see. Even our...
Where is your representation, first of all? For allotment of land, where is that application?
Well, our representation is page 56, my lord.
56. Look at your prayer. It's not even a prayer for allotment.
My lord, since prayer, our application, my lord, it is already pending. My lord, it's in the format, my lord. It's already been pending, my authority. No.
You are wrongly instructed then.
My lord.
You are wrongly instructed. Your instructions are not correct. Come to page 133. Last paragraph. In persons of so-and-so, then therefore being aggrieved, the inaction on part of the competent authority, petitioner moved read petition being so-and-so, with the direction of the petitioner to submit a fresh representation and accordingly represented the 3rd September 2015, in continuation to earlier representations was submitted before the deputy commissioner. So it's a representation for other purpose, it's not a representation for allotment of land.
My lord, may I clarify, my lord? My lord, the fact, my lord, this was not against the allotment, not against my application for allotment, but it was the claim based on the private respondent number 6, my lord.
You see, you have understood my question.
My lord.
Number one, you say that it is the question of allotment. You are referring to the order where it says allotment.
My lord.
You are making a prayer that I should not be evicted because the application for allotment is pending.
My lord, my lord.
Now
This is with the authority, my lord.
Letter of allotment you have shown is 3rd September. It doesn't even have the prayer for allotment.
My lord, that was, my lord. In that case, my lord, my lord, in that case, my lord, because our allotment was pending, my lord, it was the claim on the basis of the complaint lodged by the private respondent number 6.
Where is that application for allotment? That's what we are asking you. Where is that?
My lord, we'll have to bring it on record, my lord. That is, my lord, it was before the authority, my lord.
You see, you are unable to demonstrate either from the pleadings or from the document that the finding of the deputy commissioner, insofar as this is concerned, is wrong. We are not even referring to the High Court order by virtue of which you are directed to submit representation. And according to page 133, the representation which you submitted is 3rd of September.
My lord.
3rd of September does not have that. So to keep the matter pending, you don't find any reason. It has to be, your petition has to be dismissed. If you file an application, that will be considered by the authority, but not this application. High Court direction is for you to file a representation. If this is your representation, then it can't be kept pending. We don't find a reason to keep this eviction pending.
My lord.
That's why I refer to this judgment of Bikartan Das. As Bikartan Das, you'll find this is very clearly depicts the power of the court.
My lord. My lord.
We just have to see the decision. We can't sit in appeal.
My lord, may I pray, my lord?
Yes.
My lord, in that case, my lord, I may be allowed to withdraw this petition with fresh, my lord, to come up with all details, my lord. Okay. With allotment application, my lord.
Okay. Mr. T. Tagundan, counsel for the petitioners, as well as the GATL and additional senior government advocate appearing for the
all the respondents.
Respondents. Number
6 is private.
1 to 5. Next paragraph. In the order dated 28/1/2025, passed by the Deputy Commissioner from Itanagar, it has been mentioned that WPC 268 AP of 2015 was disposed of by order dated 31/8/2015 with a direction to the petitioners to submit a fresh representation, and accordingly representation dated 3rd September 2015, in continuation of earlier representation dated 30/6/2015 was submitted before the Deputy Commissioner, Capital Complex, Itanagar. Full stop. From the copy of the representation dated 3rd September, 3/9/2015, available on record. The court does not find any prayer made therein for allotment of the land. Next, under such circumstances, the learned counsel for the petitioner prays for leave to withdraw this writ petition and to approach this court again with all material particulars. Prayer is allowed. The matter is dismissed on withdrawal with the Mr. Thakur, we are giving you back your citations. This decision. Yes, item 12.
May I please, Your The petitioner is the serving junior engineer in the department.
I think something is wrong in this manner in which these things are taken up. If I've understood it correctly, the case of the petitioner is that the junior most person was given an officiating promotion.
Pardon, yours, I didn't get yours.
If I have read it correctly, the case of the petitioner is that one of the junior most officer in his cadre was given an officiating promotion.
Yes, Your Lordship.
From this repetition, can you tell us when was the last DPC held?
No, Your Lordship.
Or what is the policy of the government for?
Yes, Your Lordship.
Where we have said that the exercise of promotion should be carried out annually, and that is dependent on a Supreme Court judgment.
I may be allowed to take
Because you see, what happens is that if the otherwise senior most persons in the cadre remain stagnant,
yes,
and a junior most gets a officiating promotion,
yes, Your Lordship.
It sends a very wrong signal.
Yes, Your Lordship. Yes, but
We issue a notice and state. But in the meantime, you get instructions. Is it right? I have wrongly read it, or it's right? Have I understood it wrongly, or
yes, yes, correct position. Okay. That is the only case, man.
Okay. This is which department? PWD. And in the PWD, if you ask these authorities, you will find that the avenues of promotion is very less. There are people who stagnate at junior engineer level and they get the MACP and all, but they retire as junior engineers. At least that's what I have heard. I may be wrong.
no, Your Lordship.
Otherwise, we can bring instruction on this particular query, Lordship.
Yes, Your Lordship.
Otherwise, Lordship will file, Lordship, those promotee have not been implicated in this party also here in this case, because they will be affected party. Even if
no, they will currency, they have got nothing against these people. If they are giving a officiating promotion, that would be illegal.
Sometimes what happens, Lordship, in particular division, Lordship, when the particular educated engineer is not there, Lordship, the A who is serving there, they are given in charge till the Lordship, the permanent officer is.
So that's why we are asking you, when was the last DPC carried out?
That Lordship, only the petitioner can, Lordship, he has brought the case, Lordship.
Yes.
Otherwise,
when was the last promotion given? Have you filed any document? And Mr. Tapin is also right. If you have not made those persons parties, we can only issue a notice then.
Most of them, the posts are showing vacant, whereas it is made by the junior engineer.
That's what we are asking you. When was the last DPC held?
Last DPC, for last many years, no. DPC is.
Where is your statement?
I'm sorry, that particular statement is not given, madam. So
Then you
therefore,
also
madam,
notice-
what we are,
Only issue notice at this stage.
madam, what we are praying is, Lordship has correctly, madam, the observed the position, madam. That is the only Malat case. Even if Malat, the officiating is to be given, Malat, officiating has to be given from the seniority list, Malat, of the department. The
This will be-
person,
we are only issuing a notice, we can't state. The
Malat,
parties-
notice may be issued, Malat.
Okay.
Returnable within 2 weeks, Malat.
2
Since
weeks.
other
No,
respondents-
three weeks, vacation. There will be a vacation in the meanwhile.
RTI document says that Malat, the all posts are vacant, Malat, whereas it is managed by the Malat junior engineer, Malat.
It's okay. But if the concerned parties are not there, we can only issue notice.
Therefore, Malat, we in paragraph Malat, paragraph Malat 10, page number 10, we
Mr. M. Katul and counsel for the petitioners.
petitioner.
Petitioner. Also heard. Mr. S. Tapil, Learned Senior Government Advocate, appearing for respondent number 1, and Mr. Y. Ram, Learned Government Advocate, appearing for respondent number 2 and 3. Next, brother.
For all the respondents, 1, 2, and 3, Your Lordship.
It's okay, wait, we are, since he has appeared, let him please. Since we have heard both of you, we right. What's your presence? The practice of giving officiating promotion to the junior most serving junior engineer within bracket civil, while the seniors in the said cadre are stagnating without promotion, is the grievance raised in this writ petition filed under Article 226 of the Constitution of India. So the petitioner has prayed that the officiating public functional promotion to the junior most junior engineers in the junior engineer within brackets civil, in the post of assistant engineer within brackets civil in the PWD be ordered to be reverted back for a direction upon the respondent authorities to consider promotion to the petitioner and others who are the senior most junior engineer within brackets civil. Next one. Issue notice returnable on. Yes, how much time?
3 weeks time.
4 weeks, Your Lordship.
Give us a date.
Second of May, Your Lordship.
We make it earlier, 30. 30 April 2025. Next for the in view of the projection that promotional exercise has not been carried out from the post of junior engineer within bracket civil to the next promotional post of assistant engineer within bracket civil in the Public Works Department, Government of Arunachal Pradesh. B. Principal Secretary to the Government of Arunachal Pradesh, PWD, within bracket, respond number 2, and the Commissioner, PWD, Government of Arunachal Pradesh, within bracket, respond number 3, are directed to file an affidavit so as to inform the court as to when would the next Departmental Promotion Committee would be constituted. Stop. This would be in addition to whatever reply the respondents intend to make in their affidavit in opposition. Next paragraph. As the learned senior government advocate and the learned government advocate have accepted notice, requisite extra copies of the rate petition is served on them in course of the day. Next paragraph. The learned senior government advocate shall send a downloaded copy of this order to the respondent authorities, so that the said authorities would ensure that an affidavit in opposition is positively filed. That is 1 day prior to the next date of listing. Next for a list on 304/2025.
Deep level response.
May Lordship. Lordship, in this case, Lordships, here, appeal Lordships, appeal filed by a third party Lordships, before the appellate authority Lordships, where in the main suit Lordships, the appellant is not a party in the case Lordships. Lordship, I demonstrate from the annexure Lordships.
This proceeding is against the councillors.
Yes, Lordship. Councillor Lordships.
Which act is being followed?
A member of Arunachal Pradesh local urban local bodies.
Which volume?
Volume Lordship 13 Lordship 12 Lordship. Volume 12 Lordship. Volume 12 Lordship.
Who are the persons who can file?
Volume 12 Lordship.
Who are the persons who can file appeal according to this act?
Lordship, this is not given in the appeal, Lordship, but appeal should be completed within 90 days, Lordships.
Which page?
Page, Lordship, page 1, Lordship. Member of Arunachal Pradesh urban local bodies. Disqualifications on ground of defections, Act 2014, Lordship. Lordship, Section 6, Lordship. Mary, Lordship. In my case, Lordship, appeal period, Lordship, appeal time limits of 90 days is completed, Lordships. Lordship, appeal is filed on, Lordship, see from...
Just a moment. But this act does not say, it does not limit, appeal can be filed by anyone.
Lordship,
Because you see, come to page 5, section 5.
Section 5, Lordship.
A complaint that a member has become subject to disqualification. It does not say who will make a complaint.
Not made a part, Lordship. It is specifically complaint, only the complaint, Lordship. But the appeal, Lordship. It is the stage of appeal, Lordship.
An appeal against the decision of an election commission may be made so and so to the chief secretary, who shall dispose of the appeal within 90 days.
Yes, Lordship.
But who will file an appeal is not mentioned.
Yes, not given, Lordship. Specific is not given, Lordship.
But you see, under the rules of interpretation,
yes,
we cannot add any word to the legislation.
Yes, yes, Lordship.
We cannot say that this section 6 would have a limiting.
Limiting is 90 days. It's over, Lordship.
That ground, yes, sure, notice, yes.
For this, Lordship, annexures, Lordship, 6, Lordship, 6 series, Lordship. Page 66, Lordship.
66.
Yes, Lordship. Page 66, main, Lordship, 67, Lordship, order, Lordship. May I read, Lordship? An appeal under section 6(1) of member of Arunachal Pradesh urban local bodies disqualifications on ground of Defection Act 2025-24 against the order dated number so and so 01/11/2024 passed by State Election Commission Arunachal Pradesh has been received on appeal received on 18/11/2024 from Miran Komut, the president in charge BJP units East Siang district. So this is the day of appeal, Lordships. It's clearly, Lordship, provided that, Lordships, section 6 subclause 1, Lordship, it clearly provides that appeal should be shall be disposed of within 90 days of filing of such appeal, Lordship. So, Lordship, now it's still pending, Lordship. Lordship, last order, Lordship. Annexure, Lordship. Page number 108, Lordship. Last annexure, Lordship.
Okay, we will show this.
Yes, Lordship. And Lordship, may please to stay this, Lordship, proceeding, Lordship.
No, proceedings will not be stayed.
Lordship, otherwise, Lordship, tomorrow is the final argument, Lordship. Otherwise, Lordship, purpose of this filing of these writ petitions in practice, Lordships. Otherwise, Lordship. So stay this and...
No, but how can we stay the proceedings before an authority? What happens if the order is not passed?
Lordship, order is not passed still,
No,
but proceeding, Lordship, is still pending, Lordship.
Let us test this.
Yes.
You see, there are various acts which says that a proceeding should be done within 6 months.
Yes.
Now, what happens if there is a prosecution and the order is not passed within 6 months? Then what happens?
Yes,
the proceedings cannot be dropped.
Lordship, any case, Lordship, appeal is filed, Lordship, third party appeal, Lordships. That's Lordship, CPC, Lordship, CPC
will issue notice.
Yes, Lordship. CPC will govern, Lordship. CPC
we understand.
govern, Lordship.
Please tell us, if there's a requirement to pass an order within 30 days and not passed, then what happens?
No, Lordship, I own also the third party appeal, Lordships. And 2 count, Lordship, I filed this petition, Lordship.
Third party, we can't add words. Legislation, if it does not say, it does not say.
It is.
We can't limit the power of the legislature.
Or legislature, Lordship, is not clear, Lordship.
No, we can't presume that. There's a estoppel against the any aspersion against the legislature. We can't say that the any word which is not there is an omission.
Lordship, here, Lordship, in my case, Lordship, there are 2 complaint, Lordships. The petitioner, Lordship, the complaint appellant here in Lordship, the complaint made to the other 1-3 Kakaling Lordship. In my case, Lordship, complainant is different, Lordship. I saw from the record, Lordships. Lordship, if Lordship permit, Lordship, I can show, Lordship.
We are not, you see, nobody is complaining.
There is 2 complaints.
No, nobody is saying that you are incorrect.
In the main, before the election commission, State Election Commission, Lordship.
Correct. Nobody is saying you are incorrect. But please tell us the if the act does not say appeal is to be filed by whom, then it can be anybody.
Appeal can be filed by anybody, Lordship, but with the leave of the court, Lordship. With the leave of the court, Lordship. I can, Lordship, there is some authority on this regard, Lordship. The appeal can be filed by a third party, Lordship. Third party can file, Lordship. Third party can file, Lordship, but with the leave of the court, Lordship.
No,
In
you
this,
see, if you are referring to the civil procedure code,
yes, Lordship.
the civil procedure code does not say it can be filed by anyone.
No, Lordship, on citation, Lordship, authority, Lordship, I can so from Supreme Court, Lordship. Lordship, page 1 to 3, Lordship. In first para, Lordship, first para from bottom.
You see, if you are referring to this Companies Act,
not Company Act, Lord, just statement is there, Lordship.
General, we can't take a general presumption. Because when there's an appeal under the Companies Act, it is an appeal under Section 10F.
No, or in Lordship, it's just quoted, Lordships. What is there, Lordship? May I read, Lordship, this two line, Lordship, 3 line only, Lordship.
Yes.
May I read, Lordship? It is well settled that a person who is not a party to suit may prefer an appeal with the leave of the appellate court, and such leave should be granted if he would be prejudiced affected by the judgment, Lordship. In my case, Lordship, there is no leave of the court, Lordship. The appellant, Lordship, he not take the leave of the court, Lordship, before filing of the appeal petition, Lordship. If leave, Lordship, there is no issue, Lordship. In my case, Lordship, he is not leave of the court, Lordship. One more, Lordship, from live law, Lordship. One more, Lordship. One more citation, Lordship. Lordship, this is from CPC, Lordship. May I read, Lordship? Paragraph 29, Lordship. May I read, Lordship? Same things is quoted, Lordship.
He will show it to you. What is Section 90? How does 96 start? An appeal shall be.
Yes, Lordship.
Correct.
Yes, Lordship.
It does not say who.
No, Lordship. In this, Lordship, nothing is there,
It does
Lordship.
not say who.
Yes, Lordship. In this section, Lordship, but this is this, Lordship, but the authority, Lordship, I'm from, Lordship, the Supreme Court's some citation, Lordships, judgment, Lordships.
Because it's in CPC with regard to Section 96, it has been interpreted long back.
Yes, Lordship.
And that is why it is being reiterated. The appeal by a third party would be by leave of the court. There is a reason for that.
Yes, Lordship. Here in my case, Lordship, third party.
But this is not a parameter law. Because in this, the definition says political party. It contains the description of political party. Because here, if you come to this para 32.
Para 32.
Of this judgment you have now given.
Yes.
You see, this 1996 5SCC has been quoted.
Yes, Lordship.
When it is by fraud, then the affected party can file a separate suit. And that is why in the earlier case also.
Lordship, my cost, Lordship, he is not affected party, Lordship. The appellant is not a member of the Pasighat Municipal Council.
But the Act does not say restrictive application cannot be there. But in CPC, there is a restrictive clause, third party appeal by leave of the court. And that is a judicial interpretation.
Yes, judicial interpretation, Lordship.
It will not apply to each and every law.
I'm not, Lordship, on that, Lordship. Yes, judicial interpretation.
But you are issuing a notice. We will not stay the proceedings. Because the proceedings cannot be deemed to be dropped just because the judgment is not passed on a day, particular day.
Otherwise, Lordship, if tomorrow is the final hearing, Lordship, if this matter...
Help it. We keep it open.
Keep it open, Lordship. Otherwise, Lordship, this matter will be in process, Lordship. Otherwise, not.
Yeah, we understand, but we can't do it. You have to show us a law which says that if judgment is not delivered on 90th day, then on 91st day, the matter becomes contest.
I am on the
issue.
Act, Lordship. I'm on the Act, Lordship.
We understand.
Yes, Lordship.
But you must also, because you see, I deal with not only one matter.
Yes, Lordship.
There are hundreds of, not hundreds, there may be at least 15 law which says that a particular prosecution must be disposed of within 6 months. The Supreme Court has given a judgment that recent judgment a few days back, in fact, which says that an execution case filed, if not disposed of within 6 months, the judicial officer will have to be personally liable. Now, please tell us, even in that interpretation, the Supreme Court does not say that the execution petition would become infructuous.
Lordship, I accepted the Lordship view, Lordship, on the time limit, Lordship. Time limit is there, Lordship, but on the ground, Lordship.
Because if I pass one order, I'll be bound in all the orders that...
On Lordship, I especially structure these petitions on the third party, Lordship.
We get it heard.
Lordship,
Yes.
before issuing the notice, Lordship.
Yes.
There's already one matter pending before the Sonora Court pertaining to the almost same subject matter, Lordship, which has been suppressed in the present writ petition.
No, Lordship. That is the challenging the authority, Lordship. That is appellant authority, Lordship.
If Lordship see the page 67, Lordship. 67, Lordship.
67.
Against the decisions of the State Election Commission, Lordship, this appeal was filed before the Chief Secretary, Lordship. And this is the order issued by the Chief Secretary, whereby, Lordship, the order of the State Election Commission was, Lordship, stayed. This same order. And in that writ petition is pending before the Sonora Court. Here, Lordship, they have sought interim against this very order issued by the Chief Secretary.
I'm not being able to follow. Please repeat again.
State Election Commission, Lordship, they dismissed the complaint lodged by the BJP, Lordship. Then this BJP, they appeal before the Chief Secretary against this order.
Okay.
Then this order, while issuing the notice, Lordship, the Chief Secretary stayed the order passed by the State Election Commission.
Okay.
Which is at page 67, Lordship.
Yes.
Then this order has been challenged before the Sonora Court by the present petitioner.
Okay.
Which is pending before the Sonora Court, which has been suppressed in the present writ petition.
Okay, which is that writ petition?
That writ petition is, Lordship, 594 of 2024.
594 of
2024. This is the, Lordship, order.
Just,
by which, Lordship,
just give a requisition and bring that.
Lordship, that's Lordship, we challenge. I remember, Lordship.
By this order, Lordship, this Honorable Court declined to, Lordship, grant in interim against this order.
Get it
not this order, Lordship. We challenge the Chief Secretary, not a appellate authority, Lordship.
Just write it down.
We, in this case, Lordship, we are third party, Lordship. Chief Secretary, Lordship, that is a case of division bench, Lordship.
Just a moment.
Division bench. That issue is different, Lordship.
It's okay.
We challenge.
WPC 594 of 2024 releases. This matter is next fixed on, it was last fixed on 8 January 2025. This, which page you are referring to?
Lordship, page 67, Lordship.
57.
67.
67.
This order has been challenged in this writ petition, which is pending before this Honorable Court, Lordship. The order is before Lordship.
Lordship, I remember Lordship. Actually was challenged, Lordship.
Just a moment.
Paragraph 6 ko challenge.
If Lordship see the paragraph 5, Lordship, it's retail, Lordship. Challenge an order dated 10/12/20, passed in appeal number so and so. This is the Lordship at page 67.
Just let the record come. I'll take a small break and come back. I'll just take a short break and come back.
Oh, no,
The records come.
No issue.
I think other matters I'll not be able to take up. If there is any interim order to be extended, please tell the court master.
Item number 29. It may be.
No, for that we will not pass orders. It will be rolled over because today I was late in taking up all these matters. If there is any interim order to be extended, just tell the court master. In those cases, we'll pass orders. All of this will be rolled over.
My lord, if I may, number 20.
My lord, may I please say something?
Yes.
My lords, I am appearing for the petitioner in item 16. We are counsel from Delhi. May I request for a fixed date so that we can come and appear before my lords and argue this matter? Because when it's rolled over, it may not be possible. I'm just requesting for a fixed date.
Okay. Please be there. We'll pass on order. I'll just take a short break and come back. Yes.
Lordship, may I mention
Lordship, I may mention.
29, if Lordship permit me?
Item 29.
29, Lordship.
Yes.
Lordship, I am appearing for the petitioner. I am also from Delhi. So, Lordship, I am seeking some time because in this matter we have filed our rejoinder affidavit, fix the date for hearing only because I have a function tomorrow in my house. So it may be difficult to sit over till.
Okay, just wait for some time. We'll pass orders fixing a date.
Yes.
Item 29. Item number
16. My lord,
If I may mention item 20 as well.
16. Yes, I-20.
Please, my lords, this is an appeal against this is a writ petition for relief for granting of tax refund. The amount is already admitted. The government council was supposed to come up with instructions on the last date. My lords, if a fixed date may be given, this is already an admitted amount.
Okay. Okay, just wait for some time.
Please, my lord.
Come back in short time.
हाँ, हम चैलेंज नहीं किया इसको, यहाँ में चैलेंज नहीं किया, हम चैलेंज नहीं किया। यहाँ में चैलेंज नहीं किया, यहाँ में लेकिन चैलेंज नहीं किया और हाँ चैलेंज नहीं किया, चैलेंज नहीं किया, मैं इसलिए कंफ्यूज हो गया।
Yes, what do you say?
Lordship, that ground lordship, I think that order, I'm ground SL lordships on 2 count lordship third party. I whole process I challenge the process on the ground that the third party petition cannot be maintainable. And second ground lordship, expiry of 90 days, this cannot be. That is the ground in this writ petition lordship.
But then we'll have to dismiss your writ petition.
So if lordship,
On this ground, the second writ petition would not be maintainable.
Lordship, if there is a lordship, if similar lordship, I apologize lordship. If lordship.
No, not that. But under the under the procedural rules, you can't assail the same order on 2 different grounds.
Yes, Lord.
By 2 different
Yes,
writ
Lord.
petitions.
Yes, Lord. I accept.
It is hit by the principles of order 2 rule 2.
Yes, Lordship. Otherwise, Lordship, I will be allowed to withdraw.
And
allowed to withdraw, Lordship.
You'll be dismissing your writ petition.
And one important aspect is the lordship. The petitioner cannot hit both cool and lordship, hot and cool lordship. Here, lordship, the petitioner said that the chief secretary is the authority and he may be directed if lordship see the prayer number 2.
You seen that?
Directed to lordship consider as per the section lordship. And now in the present writ petition, he is stating that lordship, he is not the authority to consider this. These 2 lordship considering lordship stand cannot be taken by the petitioner. And second important is at least it should have been lordship mentioned in the present writ petition lordship. Between the same petitioner lordship. Respondents are also same lordship. It's not another party has been implicated and new party has come into. Between the same parties, it's very unfortunate lordship.
But Mr. G. Bhavan, counsel for the petitioner. petitioners. Also heard Mr. S. Tapin Danet, Senior Government Advocate, appearing for respondent number 1. By filing this writ petition in Article 226 of the Constitution of India, the petitioner projects that the proceedings of appeal number 1 of 2024, pending for disposal before the appellate authority Chief Secretary, State of Arunachal Pradesh, within bracket respondent number 1, was not maintainable, and therefore same is liable to be quashed. It is also projected that the said appeal was filed on which date?
Lordship, on Lordship 18
on 18
11
2024.
2024, Lordship.
And as the provisions of Section 6 within bracket 1 of the members of Arunachal Pradesh urban local bodies within bracket disqualification on ground of defection bracket close Act of 2014 envisages that the appeal should be disposed of within 90 days. The petitioner projects that the present appeal proceedings is liable to be dropped, and therefore the proceeding will be stayed. Next one. A preliminary objection as to maintainability of this petition is raised by the learned senior government advocate on the ground that the three petitioners herein had earlier approached this court against the same impugned order dated against the order dated 1/11/2024 passed by the appellate authority in appeal number 1 of 2024, wherein the petitioners had made admit a prayer amongst others, for passing appropriate orders in accordance with subsection within bracket 2 of section 6 of the said Act. So it is submitted that the pendency of the earlier petition has been suppressed by the petitioners. Next paragraph. The learned counsel for the petitioners has submitted that the present petition has been filed on two grounds. Firstly, that the said appeal number 1 of 2024 was filed by a third party who is not a ward commissioner, and appeal at his instance was not maintainable. And secondly, comma, that as the appeal was not disposed of within 90 days, comma, the appeal is liable to be quashed. Next paragraph. The three prayers made in WPC 594 AP of 2024 is quoted below. Page 18. So from the above, it appears that the prayer number 2 of the petitioner is to direct the respondent number 1 to pass orders in accordance with subsection 2 of section 6 of the said act. Full stop. We also take note of the fact that the appellant, at whose instance the said appeal number 1 of 2024 was filed, is arrayed in WPC 594 AP of 2024 as respondent number 3. Therefore, comma, in the earlier rate petition, comma, the issue of maintainability of the rate petition at the instance of respondent number 3 was not raised. Accordingly, comma, the present rate petition, where it is projected that the appeal by a third party would not be maintainable, is hit by the provisions of, what is that, CPC? Of Order 2, Rule 2 of the Civil Procedure Code. Which provides as follows. Order 2, Rule 2 within next paragraph. The same principle is applicable also in the writ petitions. Stop. A party who has already filed a writ petition cannot be permitted to file another writ petition to assail the proceedings on a new ground. Stop. The period so made in this subsequent writ petition is also found to be hit by explanation 4 to section 11 of the Civil Procedure Code, which provides as follows. Explanation 4, section 11 of section 11. Next paragraph. . Therefore, the objection with regard to maintainability as raised by the learned senior government advocate is accepted. And the second writ petition on a new ground of attack is held to be not maintainable. And present writ petition. Next paragraph. As regards the second issue raised, that is, if the order in appeal was not passed within 90 days from the date of filing, the proceedings should be quashed. Appears to be a proposition which cannot be accepted. There may be several laws which prescribe a particular time limit for a decision to be taken. And merely because a decision is not taken within the prescribed time would not make the appellate authority, make the concerned authority as an authority without jurisdiction. Stop. No decision of any authority has been placed on record to show that if the disposal is not made within the time allowed by a particular statute, the proceedings must be deemed to have been dropped. Stop. Therefore, insofar as the second round of attack to the proceedings of appeal number 1 of 2024 is concerned, the same is not found to be an acceptable proposition. Next paragraph. Be that as it may, as the maintainability of the representation question by the learned senior government advocate having been accepted, the present writ petition being barred by the principles of constructive res judicata, as well as under the requirement of Order 2 CPC, the writ petition stands dismissed at the motion stage without issuance of notice on the respondents. Under these circumstances, we refrain from imposing a cost on the petitioners. Now, there's 3 items. It's 14. Send back the records. Earlier you say that after the submission of with the senior government advocate, you said to ascertain the prayers made in the previous writ petition in WBC 144, sorry, not this 594 of APO 2024, the records was called for from the registry, and the same has been perused. Now, the request of 3 cases.
Please, my lord.
Date, item 16.
Yes, my lord. My lord, would 8th May be convenient to the Honorable Court?
Okay. Can we fix it on 28th of April?
My lord, I have some difficulty on that day. If there's no other date, we'll try to accommodate. Otherwise,
Okay.
we thought 8th May, my lord.
25th? Or you want it on May?
Yes, my lord.
May 2nd?
Just please, my lord, just 1 second.
16. Matter could
My
not
lords,
be.
if it's possible 8th May, otherwise we'll accommodate on 2nd May. We understand that court time is precious, but we were just making a request of 8th May because to come to Itanagar, my lord, will take 2 days. That's the reason why. But
Okay, when do
we
you
are at
want
my
to
lord's.
come? When do you want
8th
to come?
May. 8th of May.
8th would be a hearing day. We'll fix it on 7th or 9th, whenever you say.
7th is perfect.
Okay, so the 7th, both sides are represented due to positive time matter cannot be taken up. First of the Electoral Council for the petitioner submit that he's coming from outer station. And it prays for a fixed date. Next for a list on 7/5/2025.
Very grateful, my lord.
Second item is item number 20.
Item 20, my lords.
Yes, item 20.
Yes,
Can
my
we
lords.
give it-
Any date, my lord.
We give it on 28th then. Sorry, 28th.
28th April, my lords.
Yes.
Please, my lords.
Okay. Same 28th. And third is item 30. 29.
My lords, in item 20, my prayer is not to appear physically. I am being represented by an advocate locally. My only concern is that this was time fixed by the predecessor of this court. So only short time may be given because the amount is admitted.
Oh, okay. To file an affidavit. Okay.
By order dated 5 March, 2 weeks time was given to either seek instructions or to file an affidavit.
Let me the next order. Both sides are represented. The positive time matter could not be taken up today. List on 28/4/2025. Affidavit in opposition by the respondents be filed by them. Okay. In item 29 is for hearing.
Lordship, in that matter, the rejoinder has already been filed on this 13th of this month.
Pardon me?
Lordship, in item 29, rejoinder has already been filed on behalf of petitioner in response to response number 2 to 4,
Yes.
2 to 5. So that matter may be released after any date.
You're fixing a date?
After Bihu vacation. Puja.
Thank you.
Okay.
Make it 29th.
Your shape
29th of April 2025. What says it represented? The proceedings are exchanged. This is the matter for hearing on 29/4/2025. Okay. Item 24. Okay, 24. The positive time matter could not be taken up today. Interim order past resistance extended to the list of this thing. List on. Okay, 23/4/2025.